से देख कर समझ के आइए, ऐसे नहीं हम मेंशन करेंगे। 2006 का है, कुछ नहीं हम सुनेंगे, फाइनल हियरिंग करेंगे।
फाइनल हियरिंग के लिए रख दिया
कैसे रख देंगे? आप बोलते हैं कि अभी सब्स्टिट्यूशन के लिए पेंडिंग, फिर बोलते हैं आपको पता ही नहीं है कि सब्स्टिट्यूशन हुआ है कि नहीं हुआ है, फिर आपको यही नहीं पता फाइल हुआ है कि नहीं हुआ।
नहीं हो गया लास्ट
अदर साइड इज मतलब सारा कंप्लीट है। You are not sure. You are not sign. You are not sounding sure. इसका नंबर बताइए।
सेकंड अपील 194/2006।
194। इसका स्टेटस देखिए।
24/2006।
एग्जीक्यूशन में क्या हो रहा है? वहाँ तो सब्स्टिट्यूशन हो गया होगा, तभी डिड फॉर डिलीवरी ऑफ पोजीशन। वहाँ तो सब्स्टिट्यूशन कुछ भी पेंडिंग नहीं होगा फॉर श्योर।
यहाँ पर तो हो गया लास्ट पार्ट।
देखिए
ऑटो लिस्ट
अदर साइड कौन है? अदर साइड कौन है आपके? कुछ भी नहीं पता। एग्जीक्यूशन में वो डिड फॉर डिलीवरी ऑफ पोजीशन इशू हो गया, खड़े हो गए मेंशन करने के लिए।
कुछ इसमें सीनियर को मेंशन करना तो लेट्स तो आने आते वक्त कार एक्सीडेंट हो गया शायद सकता तो अर्जेंसी में आपको बोल देंगे
ऐसे नहीं अदर साइड से कंसेंट लेकर आपका मेंशनिंग नहीं अलाउ कर सकते।
सेकंड हाफ
नहीं नहीं, और आपके सीनियर को कुछ हो जाए तो इसीलिए ना आप जूनियर हैं, तो फिर आप क्या कर रहे थे चेंबर में? यस व्हाट डू
175/24 पे इसमें अर्लियर सुनने के लिए मैं
क्या मैटर?
जी मैम
क्या मैटर?
मैटर है पार्टीशन से शूट हुआ था फाइल और टोटल एंड लोड टोटल पार्टीशन डिस्कस कर हम लोग ओपी है इसमें चार पांच डेट से हम लोग आ रहे हैं, हम नहीं हो पा रहा इसीलिए मैं बोलने कर ले थोड़ा सुन लेते हैं। 13 नंबर में जा सीरियल नंबर 13
नहीं अभी नहीं वो अभी अदर साइड कौन है?
अदर साइड है यस मैम
फर्स्ट अपील नहीं हो पाएगा क्या इशू है?
कोई इशू तो है ही नहीं मैम, हम लोग गोतनी हैं हम और वो गोतनी केस कर रही है पार्टीशन के लिए। गोतनी का पार्टीशन कैसे हो?
लेकिन गोतनी केस कर रही है पार्टीशन के लिए
जी, तो यहाँ मैम कैसे नीचे लोअर कोर्ट ने डिसमिस कर दिया बजाते ये करके, और ऐसे भी ज्वाइंट प्रॉपर्टी है नहीं, उनका अपना अलग है मेरा अपना अलग है, उन्होंने एक्सेप्ट भी किया है वहाँ लोअर कोर्ट में।
कौन सा सीरियल नंबर?
13
जरा बुलाइए आगे से।
ठीक है ठीक
ये कंसेंट लेके आपको फाइल का कुछ पता नहीं होता, इसलिए आप फाइल नहीं पढ़ते। क्या मैटर? पार्टीशन सूट से इसका ठीक है, आपको आधे साइड से कंसेंट लेकर
From date is item 1 second appeal 85 or 94.
rejected. फाइल देख के आइए, ऐसे 94 प्रतिशत हमें जॉइन नहीं करना। सूट कब का है? सूट कब का है?
परसों के लिए बोल रहे थे, बात हुई थी हमारी।
कौन बोल रहे थे?
मिस्टर आयुष आए।
कौन?
मिस्टर आयुष आए थे अपने
आंसू? तो दोनों जने कंसेंट लेकर के आप लोगों को बेवकूफ बना?
नहीं, ऐसी बात नहीं है। सब्जेक्ट की परमिशन का ही होना है।
नहीं, आप तो सुने।
नहीं, हम भी आगे
देखिए ऐसा है सर, सेकेंड अपील है, पुराना है, थोड़ा देर सुनेंगे फिर हम परसों रख देंगे, हम ऐसा बात नहीं है, लेकिन समझने तो दीजिए क्या बात है।
हमको कोई एतराज नहीं। आप
इस तरह से देखिए इस तरह के पुराने मैटर्स एक दिन में नहीं होंगे, एटलीस्ट आई विल नॉट बी एबल टू डू इट। इसमें बेसिकली प्रिंसिपल ऑफ हिंदू लॉ मोहम्मदन लॉ में लगेगा कि नहीं लगेगा, दिस इज समथिंग यू नो व्हिच वी हैव टू एक्सप्लोर।
नहीं, मैटर इज ऑफ मोहम्मदन लॉ।
Matter is a Mohammedan law, whether the principle of Hindu law will be applicable in the.
Yes, this is the first question.
This is the first question.
Yes.
तो ये कोई ordinary question नहीं है, इसको बहुत ध्यान से decide करना है। ऐसे
But both questions have been answered in appellate cases.
Both the questions. The other is the point is otherwise covered by.
Yes.
आने दीजिए सर, थोड़ा देखते हैं।
Yes, sir.
ठीक है, थोड़ा देखते हैं फिर।
Yes, sir.
This is the only question of law and.
There are two questions.
Where is the other one?
Another question formulated by your lordship on 14/10/25.
24 and 25.
14/10. By order dated 14/10/25.
That's.
Second question of law in proximity, whether in spite of the clear cut.
Yes, I've seen. थोड़ा शुरू करिए,
Yes.
उसके बाद फिर से रखिए।
The second appeal is arrived from the partition suit.
नहीं ऐसे, आप फाइल है आपके पास? आप बोले फाइल छूट गया था, बिना फाइल के आप सेकंड अपील फेस कर लेंगे? बहुत एक्सपर्ट हो गए हैं, इतना एक्सपर्टीज हमको नहीं मिला अभी तक।
नहीं, जैसा हमको बताया
जी,
कल फाइल पढ़ते छूट गया उसके टेबल पे, अभी आदमी को भेजा है, अशोक नगर से लाएगा फाइल, फिर हो सकता है करे।
देखिए अगर दूसरा कोई मैटर नहीं टेकअप होता है, थोड़ा शुरू करते हैं, थोड़ा समझते हैं क्या मैटर है, ठीक है, उसके बाद परसों रख देंगे। ऐसा कोई हेस्ट नहीं है हमें डिसाइड करने का, लेकिन जब भी आप यहाँ पे टाइम लेंगे तो खुलेगा फाइल तभी जब कोर्ट में आइएगा। अच्छी बात है, दे दीजिए अदर साइड को।
तुम्हारी है कॉपी? तुम्हारी
सर के लिए आप ही को करना है ना? हाँ तो बस, अब कहाँ बहुत कम बहस करते हैं सेकंड अपील, तो धीरे धीरे करेंगे। नहीं, बीच में सीनियर को घुसने नहीं देंगे। कौन है आपके सीनियर?
Mr. Aisha.
वो नहीं परमिट करेंगे।
Pass on from.
आप फाइल मंगाइए, लेट स्टार्ट एंड 12:30 बजे, आधा घंटा काफी होगा सुनने के लिए आज।
Great.
Item 2, second appeal 22 of 1995.
यस सर, आप हैं सर।
Yes.
इसमें क्या सब्सटेंशियल क्वेश्चन ऑफ लॉ?
There is a peculiar substantial question of law has been formulated, which cannot be termed as substantial question of law.
आप अपीलेंट हैं ना?
हाँ, appellate.
तो क्या बोले बताइए?
Let kindly have a look to order dated 30th November 1995. The first question is whether the family of the parties are governed by the other school of Hindu law. Contained finding against the affair. Next is whether the facts whether in the facts and circumstances of the case, it was the defendant's onus to prove that
Bholanath Goswami
Bholanath Goswami
died
died
in
in 1926.
कल एक केस में substantial question of law.
Suit for partition. Defendant always claimed that they are governed by their Baga School of Pandura, whereas it has concurrently been found that parties are governed by Mitaksara School of Pandura.
तो इसमें कोई बिना perversity के question of law कैसे बने?
Therefore, that I submitted.
And second one.
Second one is whether in the facts and circumstances of the case, it was the defendant's onus to prove that Bholanath Goswami died in 1926.
Finding of a concurrent इसमें.
Even
Who
the
claimed?
party, it is a partition. Both parties have to prove their case.
That's right.
And in both the courts below, it has been held that Bholanath Goswami had died after 26. I will permitted to refer the finding of the appellate court only.
After 26 के अलावा कुछ नहीं बोले.
After, there is nothing else.
After का मतलब नहीं पता.
After it has come in the appellate judgment.
Because maybe 1926 was a crucial date.
Crucial date whether daughter will inherit or not.
Okay.
ताकि उसकी बेटी से प्लेंटिफ को जमीन लिखवा दिया. And therefore they are claiming if they are guided by Deavaga School of Hindu.
Oh. तो ऐसे ही डिसमिस कर देते हैं concurrent finding को क्या करेंगे आधे सही को.
Concurrent है दोनों.
थोड़ा दिखाएंगे सर. थोड़ा फाइव.
Yes. Well, that. Let take help for.
हाँ yes yes. ट्राई कोर्ट का जजमेंट देखिए.
Trial court judgment starts from running page 32.
You can refer to the internal pages because it is not numbered. Right? ठीक है जजमेंट से शुरू से देख रहे. टाइटल सूट 14.
14 of 82.
82. Were you born in 82?
Yes, sir. No, sorry.
Yeah.
तो आपके जन्म से पहले का केस है. हाँ टाइटल सूट.
Issues are at page 5.
एक सेकंड. केस ऑफ रेस्पेक्टिव पार्टीज बिना पढ़े इश्यूज नहीं पढ़ सकते. पढ़िए सर.
From the first.
सर आप आराम से बैठिए. अदर साइड कोई अपीयर नहीं होता है इसमें.
Yes, Mr. Mukhopadhyay was very at last occasion. क्या मुखोपाध्याय नाम है क्या? BK Mukhopadhyay.
चलिए please.
This is a suit for partition of the property mentioned in the schedule of the claim. The case of the plaintiff in short is that land after claiming to Moza, Lakiawad, Jipur and Delhi were recorded in the name of Hingal Goswami, one share. Jagannath Goswami, Motilal Goswami, son of Nagar Goswami and Kaushalya, wife of Sagar Goswami, jointly another share. It is further submitted that Hingal Goswami had three sons, Duryodhan Goswami, Puranlal Goswami and Bholanath Goswami. Hingal Goswami died in and about the year 1936. It is further submitted that defendant number 1 to 3 represented the branch of Duryodhan Goswami, while defendant number 4 to 12 to 10
4 to 12.
4 to 12 represent the branch of Puranlal Goswami, the plaintiff, and the defendant's second party are the descendants of Bholanath Goswami. It is further submitted that after the death of Hingal Goswami, his three sons inherited the property left by Hingal in equal share. Bholanath Goswami died after the death. Bholanath died After his death, his share was inherited by his daughter, Gulanchi Devi. Gulanchi Devi was married at Kaladi, PS Govindpur district, Dhanbad. The plaintiff and defendant second party are the heirs of Gulanchi Devi. It is further submitted that the family of the plaintiff and defendants are governed by the Bhaga school of Hindu law. Further case of plaintiff is that Gulanchi Devi died in or about the year 1976. After her death, the share of Gulanchi Devi was inherited by the plaintiff and defendant second party. It is further submitted that the share of Jagannath Goswami, Motilal Goswami and Kaushalya Devi were partitioned long before between Hingla Goswami and aforesaid persons. The plaintiff did not claim over the property which fell in the share of Jagannath Goswami, Moti Goswami and Kaushalya Devi. The plaintiff has filed this suit only for partition of the property which is mentioned in Schedule B of the plaintiff. It is further submitted that after the death of Hingal Goswami, his three sons possessed the property jointly for the convenience sake. They separately cultivated the land possessed the same. There was never any partition by meets and bounds. After the death of Bholanath Goswami, Gulanchi Devi got his share and cultivated the land through her Bhagidars. It is further submitted that as long Gulanchi Devi was alive, there was no trouble between the family. But after the death of Gulanchi Devi, trouble started in the family regarding usufruct of the land and cultivation. The plaintiff requested the defendant first party for partition. Previously, the defendant's first party agreed to partition the property, but subsequently they did not agree to partition the property, hence the necessity of the suit. The plaintiff claimed 2/9 of the share in the entire scheduled property, while 1/9 share belonged to defendant's second party. It is further submitted that in Khata number 42 of Mauza Jeep Court, where Kurpa right, but the Kurpa right abandoned in their claim long before the land reverted back into the khas possession of the plaintiff and defendant's second party. And so this land was also included in partition. The plaintiff praying that the court may be pleased to pass a decree of partition declaring 2/9 share of the plaintiff in Schedule B property, and the court may further be pleased to appoint leader commissioner for allotting the separate takta of the plaintiff. The cost of the suit and other reliefs which the court may think fit and properly pass in favor of the plaintiffs. Defendant number 1 and 2 appear and file the written statement. Other defendants have not filed the written statement nor even contested the suit. So the suit is proceed ex parte against them. The case of defendant number 1 and 2 in short is that suit as claimed is not maintainable. The plaintiff has no valid cause of action or right to sue. The suit is barred by law of limitation and also under the principles of estoppel, waiver, and acquiescence. The suit is banned for misjoinder and non-joinder of parties. There was no unity of title. So far as plaintiff is concerned, and as such, the suit is banned. The suit is also undervalued. The suit property has valued more than lakh of rupees.
So नीचे से दो तीन लाइन. It is further submitted that खाता
It is
number 40.
further submitted that all the properties has not been brought for partition to the suit. The suit cannot proceed. It is further submitted that Khata 43 of Mauza Jeepur land has not been included in the partition suit, so the plaint is defective. The defendant's second party has no unity of title and possession over the suit land, so the suit must fail. It is further submitted that the land situated in Mauza Jeepur, Delhi and Bhakiabad were recorded in the name of Jagannath Goswami, Hinglal and others. It is further submitted that Khata 42 of Mauza Jeepur stand in the name of Hinglal Goswami and his co-sharers, which were not included in the suit property. It is further submitted that Hinglal Goswami died in the year 1928. Bholanath Goswami died before Hinglal Goswami. The parties were governed by Mitashra School of Hindu Law and not by Dayabhaga School of Hindu Law, as alleged by the plaintiff. It is further submitted that after the death of Hingal Goswami, his share was not inherited by his three sons because Bholanath Swami died before Hingal Goswami. So the share of Himlal Goswami was inherited by Duryodhan Goswami and Puralal Goswami. Bholanat Goswami has no male issue. He has only daughter Guranchi Devi. Duryodhan Goswami died in or about the year 1935 and Puralal died in the year 1936. Bholanat Goswami died in the year 1926. So the interest of Bholanat Goswami inherited by the nearest reversion, that is Duryodhan Goswami and Puralal Goswami. Duryodhan Goswami and Puralal Goswami remained in possession of half property, and after death of Duryodhan Goswami and Puralal Goswami, the descendants of Duryodhan Goswami and Puralal Goswami came in possession of the land. Guranchi Devi never came in possession of the land, and Guranchi Devi has no right, title, interest, and possession over the land left by Himlal Goswami. Guranchi Devi was married at Kaladi and she remained there with her husband. So Guranchi Devi has no concern of the property left by Himlal Goswami. The defendant's second party never inherited the property left by Himlal Goswami, and the defendant's second party have no right, title, and interest or possession over the property left by Himlal Goswami. It is further submitted that the plaintiff has no right, title, and interest over the land mentioned in Schedule B of the claim, because Gulanchi Devi was the mother of plaintiff. Gulanchi Devi has no right, title, interest in the suit property, then automatically the plaintiff and second party have no right, title, interest over the suit property. The plaintiff has no right to file the partition with regard to any of the land described in the schedule of the claim. It is further submitted that the submission of the plaintiff that Bholanat Goswami died after the death of Himlal Goswami is not correct. Bholanat Goswami died before Himlal Goswami. Bholanat Goswami never came in possession of the land mentioned in Schedule B of the claim. Guranchi Devi also not came in possession of the land mentioned in Schedule B of the claim, as alleged by the plaintiff. Guranchi Devi or plaintiff never cultivated the land through their bataidas as alleged by the plaintiff. It is further submitted that Guranchi Devi or the plaintiffs were never in possession of the land, so the question of any trouble regarding the usufruct of the land and cultivation of the land never arose in the family. It is further submitted that there was no occasion for the plaintiff to ask for partition from the defendant first party, because the plaintiff and defendant second party have no right, title, interest over the suit land. The claim of the plaintiff that they are entitled to 1/3 share in the property mentioned in schedule to the plaintiff is false one. It is further submitted that defendant first party along with other co-sharers have filed several suits regarding the land. Some lands were recorded as Kurfi land, for which the suits were filed by the defendant's second party in the year 1930, in which Bholanat Goswami was not a party, so it shows that Bholanat Goswami died prior to 1936. If Bholanat Goswami died before 1936, then automatically heirs of Bholanat Swami will not inherit the property left by Himlal Goswami. There were several cases filed by the defendant first party in which the plaintiff or defendants were not included as a party. It shows that the plaintiff or defendant second party have no right, title, interest over the suit property. It is further submitted that some lands were sold by defendant first party, but the purchaser of the land was not made a party in the suit, so the suit is back for non-joinder of parties. The defendant submitted that there was no valid cause of action to file the present suit. The plaintiff is not entitled to any relief or release as claimed for by, and the suit is fit to be dismissed with cause.
Now the issues.
Three issues are framed.
That's four issues. Five issues.
Five issues. Is the suit framed as maintainable as a plaintiff valid cause of action or right to sue? Is the suit barred by principle of estoppel, waiver and acquiescence and by law of communication? Is the plaintiff entitled to declare a claim for? To what other relief the plaintiff is entitled?
Which issue we are concerned with in this case?
Issue number 4.
Issue number 4. Okay. What is the finding? What is the finding?
Finding is that finding towards page
Plaintiff is entitled for decree of partition, right?
14.
Page 14. But actually, the discussions in connection with the substantial question of law, I want to see.
Yes, sir.
there is finding in page number 10 bottom also. You come to page number 9, in the present suit. Next question. This para 11 is whether parties are governed by Mitakshara law or
Let's start from para 11.
Yes. Death of Bholanath in the year 1926. You get this finding in para 10. Right?
Yes.
You come to para 10.
Para 10.
Para 9 is the witness list. Yes.
Para
It
10.
is clear that Bholanath died when in first party has failed to prove from the oral evidence that Bholanath died in the year 1926.
Preceding para.
The preceding paragraph. I just marked it. So, from the perusal of oral evidence, it is clear when Bholanath died, the defendant among first party has failed to prove from the oral evidence that Bholanath died in the year 1926. Then para 10.
Now coming to the documents filed by the parties, the defendant first party filed a certified copy of claim entitled suit number 64 of 36, which is exhibit B. The plaintiff
64 of 30.
which is exhibit B. The plaint of title suit number 65 30 is exhibit B by 1 on the report. From these documents, the defendant's first party wanted to show that in both the claims, it was shown that Duryodhan Goswami and Purandar Goswami are sons of late Hinglar Goswami. It means that Hinglar died before 1930. In exhibit B and B by 1, which are the plaint of title suit number 6430 and 6530, the name of Bholanath was not mentioned. If Bholanath was alive at that time, certainly he would be a party in both the suits, but the name of Bholanath was not mentioned in title suit 64 and 65 of 30. It goes to show that Bholanath died prior to 1930. The plaintiff's lawyer contended that only the name of Bholanath was not mentioned in the claim. It will not establish that Bholanath died in the year 1926. Title suit number 64 of 30 and 65 of 30 were filed against the Kurpa area, so it is not necessary to implicate all the co-sharers of both the aforesaid suit. Exhibit B and B by 1 are not the proof of death of Bholanath. The submission of plaintiff lawyer seems to be tenable. The plaintiff of PW6, who is one of the plaintiffs in the present suit, has also explained in his evidence that Bholanath was not a party in the aforesaid suits because Duryodhan and Purandar were looking after the suits. Bholanath did not look after the suit, so he was not included as party in title suit number 6430 and 6530. The explanation given by PW6 are reasonable. So, from the documents as well as the oral evidence adduced by both the parties, it will not be clear that Bholanath died in the year 1926. Prima facie, the burden lies upon the defendant number 1, first party, who alleges that Bholanath died in the year 1926. The defendant first party had failed to prove that Bholanath died in the year 1926. In absence of the evidence, it is difficult to hold that Bholanath died in the year 1926. So the contention of the plaintiff that Bholanath died after 1926 can be accepted. Now the next question is to be decided whether the family of the parties were governed by Mitakshara School of Hindu Law or the Yabhaga School of Hindu Law. The plaintiff made the assertion in the claim that the families were governed by the Yabhaga School of Hindu Law, whereas the defendant first party stated in the written statement that families were governed by Mitakshara School of Hindu Law. On this point, there is absolutely no oral evidence adduced by the parties. PW1, 2, 3, 4, 5, and 6 have not stated their evidence clearly that the families were governed by the Yabhaga School of Hindu Law. Similarly, DW1, DW2, 3, 4, 5, and 6 and 7 have not deposed in their evidence that the families were governed by Mitakshara School of Hindu Law. At the time of argument, defendants lawyers contended that general presumption is that the families were governed by Mitakshara School of Hindu Law unless contrary is shown. In the present suit, plaintiff has failed to prove that the families were governed by Jharkhand School of Hindu Law. It means that the families were governed by Mitaksha School of Hindu Law. On the other hand, defendant's lawyers contended that the families were governed by Jharkhand School of Hindu Law, as proved by the documents filed by the plaintiff. The documents filed by the plaintiff, it cannot be reverted by the defendant during the hearing of the suit, nor the defendant first party has challenged the genuineness of these documents. In the present suit, one thing is to be remembered that previously, Dhanbad district was within Purlia subdivision. Purlia subdivision was part of Mangun district. Subsequently, some part of Purlia subdivision was divided and Dhanbad came into Bihar province and Purlia formed part of West Bengal state. So, it will be presumed that Bengal School of Hindu Law, that is the Bhaga School of Hindu Law, was prevalent between the parties since the Bhaga School of Hindu Law was common in Bengal, whereas in other provinces, Mitaksha School of Hindu Law prevails. So in this case, presumption is not drawn in favor of the defendant, first party, that Mitaksha School of Hindu Law was prevailed unless contrary is shown. Exhibit 1, 1 by A and 1 by B are the Khatiyan of Malda, Jipur, Lakhiabad and Billy. These Khatyans were recorded in the name of Inglar Goswami, Jagannath Goswami, Gangadhar Goswami, Kaushalya and others. Exhibit 1 is the Khatyan of Malda, Jipur. The Khatyan was prepared in the year 1925 before commencing of Hindu Women Right to Property Act 1937. From perusal of Exhibit 1, I find that the name of Kaushalya Devi is there. If the family was governed by Mitaksha School of Hindu Law, then in that case the name of Kaushalya Devi was not mentioned in the Khatyan, which was prepared in the year 1925. It goes to show that the families are governed by Dayabhaga School of Hindu Law. In Dayabhaga School of Hindu Law, the share of heirs are definite in Dayabhaga School of Hindu Law. The female is also entitled to their share left by the deceased. On the other hand, in Mitaksha School of Hindu Law before 1937, after the death of a deceased male owner, the property passed to the next
Reversionist. If the member of the deceased was not alive.
Exhibit 1 clearly shows that Kaushalya Devi was the wife of Sagar Goswami. It shows that Gangadhar Goswami died, and after the death of Gangadhar Goswami, his interest was inherited by Kaushalya Devi. Clearly proved the version of the plaintiff that family was governed by the Dayabhaga School of Hindu Law. If I come to the conclusion that the family was governed by the Dayabhaga School of Hindu Law, then if for the argument's sake it will be presumed that Bholanath died in the year 1926, then in that case also, Gulanchi or the widow of Bholanath will inherit the property left by Bholanath. DW7 has clearly stated in his evidence that after the death of Bholanath, his widow, namely Tomni, and his daughter Gulanchi Devi lived in the house of Bholanath. The widow of Bholanath died, and after the death of Bholanath, 8 to 10 years after, the evidence of DW7 clearly shows that the widow of Bholanath and daughters of Bholanath reside in the same house in which Bholanath resided. So I come to the conclusion that the family was governed by the Bhaga School of Hindu Law. In absence of any proof, it cannot be said that Bholanath died before 1926. If Bholanath died after 1937, certainly in that case the widow of Bholanath will get the share in the property left by Bholanath, and the property may not pass to the reversionary to Bholanath, that is, brother of Bholanath and heirs of Bholanath. Now in this case, it will be necessary to consider whether the plaintiff was in possession of the suit land or not left by Bholanath. The plaintiff asserts that after the death of Bholanath, his daughter Gulanchi Devi came in possession of the land, and she
Is it important for the question of law? वो तो दयाभागा तो हो गया खत्म। अच्छा ये दूसरा वाला
826 वाला भी हो गया, उसी डेट ऑफ डेथ वाला।
हाँ वो भी हो गया। whether in the facts and circumstances of the case it was the defendant's onus to prove that the Bholanath died in 1926. 1926 में अगर भोलानाथ का डेथ हो गया तो इसमें डिपेंडेंट को क्या फायदा?
डिपेंडेंट को इसलिए कि उनकी बेटी बेच चुकी थी डिपेंडेंट को.
Yes.
और डिपेंडेंट जो है कमी इन पॉजिशन एक्सक्लूसिवली.
Okay.
ये प्रॉपर्टी पार्शियल पार्टीशन है.
That's right. But that is not the question of law. That I've seen.
Therefore, I did not raise this question. But partial partition is a pure question of law.
That's right.
And therefore, raising this, that partial partition, admittedly, there were certain partition suits earlier.
अब कौन है? Defendant है, plaintiff.
Defendant plaintiff, then plaintiff appellate.
Plaintiff appellant.
Plaintiff appellate.
Plaintiff appellant.
Sorry, ma'am. Defendant appellate.
ये डिग्री हो गया सूट.
हाँ, सूट डिग्री हुआ, अपील फाइल किया था डिफेंडेंट, वो डिसमिस हो गया, and therefore this second appeal.
पार्शियल पार्टीशन के लिए तो दूसरा.
पार्टीशन का केस मेट आउट हुआ है, but इशू फ्रेम नहीं हुआ.
सर नहीं चलेगा सर. सर नहीं चलेगा.
क्योंकि इशू फ्रेम नहीं होता है इसलिए जजमेंट लेट नहीं आया है, but I got the reference.
सर उससे नहीं होगा क्योंकि पार्शियल पार्टीशन में भी आपको दिखाना पड़ेगा कि there were other properties and which were those properties.
From the pleading itself, you have also will find that there were certain
beyond substantial question और नहीं जाएगा उसका.
Therefore,
बस ये इतना पुराना सूट.
I surrender that to the
Yes, yes. एपिलेट कोड बताइए. एपिलेट कोड बताइए.
Finding starts from internal page 6 not.
हाँ बताइए. Yes.
The learned trial court framed 5 issues. Under issue number 4, the trial court decided the question whether the plaintiff is entitled to a degree as claimed for. He decided that the questions in the affirmative under this issue. The learned trial court examined the point whether the family of plaintiff and contesting defendants was governed by the Jharkhand School of Hindu Law or Mithakshara School of Hindu Law, and found from the evidence on record that they are governed by the Jharkhand School of Hindu Law. The learned lower court found that it is admitted by the parties that Hingal Goswami had 3 sons, Duryodhan, Puranath and Bholanath, and Gulanchi Devi was daughter of Bholanath Goswami, and that the defendant's second party are the descendants of Gulanchi Devi. It is also admitted by the parties that the land in dispute are recorded in the name of Jagannath and Hingal, and that it appears that the contesting defendants in the lower court as well as in this court contended that the family of plaintiffs are governed by Mithakshara School of Hindu Law, in which females were not the co-partitioners, and as Bholanath Goswami died in or about the year 1926, her daughter Gulanchi Devi did not inherit him, as she was not entitled to inherit under the Mithakshara School of Hindu Law, which governs the sole property. The learned trial court found that the contesting defendant have not given evidence in support of their claim that the sole property is governed by Mithakshara School of Hindu Law. The learned trial court has correctly opined that the parties are to prove the School of Hindu Law which governs them, because it is their personal law. The learned trial court found that the family of plaintiff and contesting defendant have Bengali language and culture and have come in Bihar state due to reorganization of the boundaries of Dhanbad and Purulia district, which were earlier in Mangun subdivision, where Bengali language and culture was prevalent, and the Jharkhand School of Hindu Law was developed. The finding of the learned trial court is correct because the School of Law had personal laws, and the rule of that lex loci does not apply. So the learned lower court did not take the presumption that in Bihar, the Taksha school of Hindu law is applicable to the property involved in the suit. On perusal of record, I find that the contesting defendants have not adduced evidence to support their claim that the plaintiff and the contesting defendants are governed by the Taksha school of Hindu law. The lower court has correctly found that the suit trials thus previously were in West Bengal and as such law of presumption could not be made in favor of the contesting defendant in the Taksha school of Hindu law is applicable. In this regard, the learned trial court looked into the exhibit number 1 by A and 1 by B, the Khatyan of Mazajipur, Lakiabad and Delhi, recorded in the name of Himla Goswami, Jagannath Goswami, Gangadhar Goswami, Kaushika Devi and others. The Khatyan were prepared in the year 1925, when the Hindu Women Right to Property Act 1937 was not in existence. And at that time, the name of Kaushika Devi was recorded in Exhibit 1, which clearly indicated that female was also entitled to inherit in 1925. The lower court has thus come to a definite finding that the entry of name of Kaushika Devi, a female in the record of right, proved that the Bhaga school of Hindu law is applicable. This finding of learned lower court is quite correct. I perused the Khatyan and I find that Kaushika Devi is recorded as tenant with other male sharers. The contesting defendant could not falsify the said entry of Kaushika Devi in the said record of right. So it appears that the main point of contention of the contesting defendant that the suit property is covered by the Daksha school of Hindu law is not maintained and other objections of position based on the said contention becomes fertile. The learned trial court has said that the plaintiff has not been made party and the various suits and cases filed earlier, and as such, the finding in the suits and cases are not binding upon the plaintiff. This finding of the learned trial court appears to be just and legal. The learned trial court considered the evidence to find when Bholanath Goswami died. The burden to prove that Bholanath Goswami died in 1926 was upon the contesting defendant, who had asserted in the written statement the same. But the trial court, on the result of defense witness 1, Tikaram Tudu, DW3, Kistu Manji, DW4, Prabhu Goswami, defendant number 1, and defendant number 7, Nitai Mandal, found that they have not given any reliable oral evidence to prove that Bholanath Goswami died in 1926. The defendant contention was that.
So there was nothing to say as to when did he die, as to whether he died in 1926 or not, but he certainly died before 1930.
Before.
That is the finding.
Yeah.
That is before coming into force of the Hindu women's right to property.
In any case, daughter of Bholanath
Yes.
was liable to be inherited after death of Bholanath.
Yes. और उनका नाम क्या था? डॉक्टर
मिताक्षरा स्कूल में है 37 एक्ट और उसके 56 एक्ट उसके बाद लेकिन
दयाभागा में तो पहले से ही है
पहले ही थे
दयाभागा में तो पहले से ही है that was always
soon the father died other heirs are entitled
and Kaushalya Devi is daughter of
Kaushika Devi was daughter is Bholanath's daughter is Bulachi Devi.
and Kaushalya Devi
father
Kaushika Devi is the widow also.
anyways but it has come that he died prior in 1936 then prior to 1936 at least if not 26 but certainly prior to 1936
prior to 1930
आपको कुछ बोलना है सर
बोल रहे हैं कि पार्टीदार गवर्नमेंट पर दयाभागा स्कूल ऑफ हिंदू लॉ बंगाल में दयाभागा चलता था बिहार में मिता चला तो ये बंगाल से सटे एरिया है बांग्लाभाषी लोग हैं जो दयाभागा स्कूल ऑफ हिंदू लॉ के अनुसार बुलंची देवी डॉक्टर भोलानाथ गोस्वामी उनका सी हैज अ वेरी राइट टाइटल
so according to you this is not a substantial question of law ये तो एकदम question of fact है
both the courts
have given concurrent findings
both the courts
this is what you want to say this is what they have also said
my only objection is that partial party since it was not raised in any court no issue was there therefore I did not file interrogatory application
that's it I appreciate that
additional issue
ठीक बात है.
That's all.
देखिए, essay number 22 of 1995. Heard the learned counsels appearing on behalf of the parties. This appeal has been filed. Against the judgment dated 20/4/1995, within bracket decree signed on 1/5/1995, bracket close, passed by learned 6th additional district judge Dhanbad, entitled appeal number 94 of 1989. Whereby the appeal has been dismissed and the judgment dated 30/8/1989, within bracket decree dated 13/9/1989, bracket close, passed by learned Sub-Judge Roman Ford Dhanbad, entitled suit number 14 of 1982, has been confirmed. The suit was filed seeking partition of Schedule B property, and the suit was decreed. The defendant filed the appeal. The appeal was dismissed by the learned first appellate court. Consequently, the defendant is the appellant before this court. This appeal was admitted for final hearing by the order dated 30/11/1995 on the following two substantial questions of law. The learned counsel appearing on behalf of the respondent, representing the plaintiff, at the first instance has submitted that the points formulated as substantial question of law are not substantial question of law in the eyes of law. They are essentially questions of facts, and both the courts have given clear finding that the parties were governed by the Abhaga school of law, and it was the defendant's onus to prove that Bholanath Goswami died in 1926. As the defendant asserted that Bholanath Goswami died in the year 1926. The learned counsel submits that both the courts have given concurrent findings after appreciating the materials on record, and therefore these are not substantial questions of law at all. He has also submitted that in the first appeal, in absence of any perversity, there is no scope for reappreciating the materials on record, and has submitted that this appeal be dismissed. The learned counsel for the appellant has placed the judgment passed by the learned trial court as well as the appellate court, and has submitted that though the questions are essentially question of facts, but once it has been framed, the same is required to be answered. यही बोलेंगे आपकी तरफ से? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that it is an admitted fact by the parties that Hinglal Goswami had three sons, Duryodhan, Puranlal and Bholanath. And Gulanti Devi was the daughter of Bholanath Goswami. And that the defendant second party are the descendants of Gulanti Devi. It is also an admitted fact by the parties that the land in dispute are recorded in the name of Jagannath and Hinglal and others. This court finds that the suit was filed, being title suit number 14 of 1982, seeking partition of land recorded in the name of Hinglal Goswami, claiming one share and Jagannath Goswami, Motilal Goswami, sons of Gangadhar Goswami, and Kaushalya Devi, wife of Sagar Goswami, jointly another share. It was the case of the plaintiff that Hinglal Goswami had three sons, Duryodhan Goswami, Puranlal Goswami and Bholanath Goswami, and Hinglal died in or about the year 1936. The defendant number 1, 2, 3 were representing the branch of Duryodhan Goswami, while defendant number 4 to 12 were representing the branch of Puranlal Goswami, and the plaintiffs and the defendant's second party were the descendants of Bholanath Goswami. It was their case that after death of Hinglal Goswami, his three sons inherited the property left by Hinglal in equal share. Bholanath died, and after his death, his share was inherited by his daughter, namely Gulanti Devi. The plaintiff and the defendant's second party had the heirs of Gulanti Devi. It was their case that the plaintiffs are governed by Vyabhaga School of Hindu Law, and Gulanti Devi died sometimes in the year 1976, and after her death, the plaintiff and the defendant's second party had inherited the property of Gulanti Devi. The defendants, कितना fact काफी होगा? The defendants, defendant number 1 and 2, contested the suit, and the other defendants did not file their written statement, nor they contested the suit, and the suit proceeded ex parte against them. The specific case of defendant number 1 and 2 was that the suit was not maintainable, there was no unity of title, and it was a specific case that parties are governed by Mitakshara School of Law and not by Vyabhaga School of Law. It was also the case that Hinglal Goswami died in the year 1928 and Bholanath Goswami died before Hinglal Goswami. it was their specific case that Duryodhan Goswami died in or about the year 1935 and Puranlal died in the year 1936 and Bholanath Goswami died in the year 1926. It was their case that after death of Hinlal Goswami, his share was not inherited by his three sons because Bholanath Goswami died before Hinlal Goswami. So the share of Hinlal Goswami was inherited by Duryodhan Goswami and Puranlal Goswami. The interest of Bholanath Goswami was inherited by his nearest relation, that is Duryodhan Goswami and Puranlal Goswami, who got half share each. And after their death, their descendants came in possession of the property. It was their case that Gulanji Devi never came in possession of the property involved in this case and had no right, title, interest and possession. The first appellate court, the learned trial court, the learned trial court framed the following issues for consideration, para number 5. The counsel for the appellant has submitted that the substantial question of law are relatable to the issue number 4 in the present case. The learned trial court first took up the issue number 4 and in paragraph 7 of the trial court judgment observed that the question of dispute was that the plaintiff submitted that Bholanath did not die in or about the year 1926, whereas the defendant claimed that Bholanath died in the year 1926 before the death of Hinlal. The learned trial court has considered the materials placed on record and in paragraph 9 of the trial court's judgment, the learned court observed that from the perusal of oral evidence, it was clear that Bholanath, it was clear that when Bholanath died, the defendant first party had failed to prove from oral evidence that Bholanath died in the year 1926. The learned court thereafter considered the documentary evidences placed on record and ultimately observed that from the documents as well as the oral evidences adduced by both the parties, it will not be clear that Bholanath died in the year 1926 and observed that prima facie the burden was upon the defendant first party who alleged that Bholanath died in the year 1926, which the defendant first party failed to prove. The learned first trial court was of the view that in absence of the evidence, it was difficult to hold that Bholanath died in the year 1926, and the contention of the plaintiff that Bholanath died after 1926 was accepted by the learned trial court. The finding of the learned trial court has been arrived at after considering the materials placed on record and during the course of hearing, the learned counsel for the appellant has not been able to show any perversity in the matter of appreciation of evidence by the learned trial court, and also the approach of the learned trial court with respect to the onus upon the defendant to prove that Bholanath died in the year 1926 as it was a specific case of the defendant that Bholanath died in the year 1926, which was certainly required to be proved by evidence by the defendant themselves. With respect to the point as to whether the parties are governed by Mitaksara school of Hindu law or Dayabhaga school of Hindu law, the learned trial court took up the matter right from paragraph number 11 onwards, and after considering the materials on record, including the fact that the area to which the parties belonged were of were which was Purulia, which formed part of the West Bengal state, and also the Khatian of the year 1925. The learned trial court came to a clear finding that the family was governed by the Abhara school of Hindu law. The learned court was of the view that in absence of any proof, it could not be said that Bholanath further observed that in absence of any proof, it could not be said that Bholanath died before 1926. The court also observed that if Bholanath died after 1937, certainly in that case the widow of Bholanath will get the share in the property left by Bholanath, and the property may not pass to the reversionary of Bholanath, that is brother of Bholanath and heirs of Bholanath. The learned court ultimately allowed the suit for partition and directed that the plaintiff and defendant second party would be entitled to get decree of 1/3 share in the property mentioned in Schedule B of the plaintiff. Similarly, heirs of Puranlal and Duryojan were entitled to get 1/3 share each in the property described in the Schedule B of the plaintiff. So far as the learned, with respect to the finding of the learned trial court that the parties are governed by the Abhaga school of law and not Mitaksara school of law, the learned counsel for the appellant has not been able to point out any perversity in the matter of appreciation of evidence or the approach of the learned trial court by coming to such a finding. So far as the learned first appellate court is concerned, the first appellate court has also considered the materials and has given concurrent findings, and no error in the approach of the learned first appellate court has also been pointed out by the learned counsel for the appellant. This court is of the view that both the substantial questions of law are essentially questions of facts, and both have been answered in favor of the plaintiff who was seeking partition. This court finds that the family of the parties were certainly governed by Vyabhaga law, Vyabhaga school of Hindu law, and once the defendant was claiming that Bholanath died in the year 1926, the onus was certainly upon the contesting defendants to prove the year of death of Bholanath Goswami. This court finds that in view of the aforesaid facts and circumstances, this court, in view of the substantial question of law so framed, this court has gone through both the judgments and has not found any perversity in the approach of the learned courts by dealing with the aforesaid facts. In such circumstances, both the substantial question of law are answered against the appellant and in favor of the respondents. This appeal is hereby dismissed. आपका तो 12:30 बजे बुलाया है, तब तक फाइल पढ़ लीजिए।
हम पढ़ लियो, मिस्टेक से छूट गया था।
नेक्स्ट केस 175 is what?
Yeah.
कौन है इसमें अदर
दोनों साइड।
We are on behalf of the respondent. Appellate sir, but he has mentioned this case without any information.
No, that is why I asked him to
Next
inform
week
that.
we इसको रख दिया जाए।
Sorry?
Next week में रख दिया। Next week. Immediate, whichever is convenient before this honorable कर लेंगे।
मैम छोड़ डेट से हम लोग आ रहे हैं, जा रहे हैं।
देखिए इतना स्पीड हमको नहीं है।
नहीं मैम, देखा जाए मैम खाली
नहीं, अभी तो फाइल खुला भी नहीं है।
मैम डेट एक बार 6 महीना का लगा। पिछले बार मैम ये एक बार 6 महीने तो यही चाहते हैं
अभी को इन्फॉर्म किए मैम।
6 महीना बाद डेट मैम देखा जाए।
What he said
देखिए आपका कब का केस है? लाइए तो इन पे मेरा फाइल देखिए। केस लिस्ट में आने का मतलब नहीं है कि फर्स्ट अपील सेकंड अपील इतना टेकअप हो जाएगा। 100 केस लिस्ट में लगता है। आपको लगता है हो जाएगा? एक फर्स्ट अपील में पूरा दिन का 3 दिन भी लगता है।
यस मैम,
है ना?
यस मैम।
लिस्ट में इसलिए रहता है कि आपको पता होना चाहिए कि कोई, तो अगर आप कहाँ से आते हैं? बोकारो से थोड़ा तो एसेस करके आना चाहिए ना, थोड़ा तो एसेसमेंट आपको होना चाहिए।
यस मैम,
है ना?
यस मैम।
इसीलिए ये बोलना कि इतना दिन से आ रहे हैं नहीं टेकअप हो रहा है, थोड़ा सा मुश्किल लगता है।
मैम 6 महीना पहले जो हुआ था मैम ना, तो मैं उन्होंने डेट लिया था, मैं एक बार 6 महीने के बाद का मैम
ये एडवांस नोटिस का सर्कुलेशन था 17/3 का इनका, ठीक है? इसमें कॉस्ट भी लग गया था। किसको कॉस्ट लगा था? आपको लगा
जी।
पंद्रह 1/2025 तक तो नोटिस पर ही चल रहा है।
जी।
ठीक है, तो इसीलिए ये मत बोलिए कि बहुत दिन से चल रहा है।
वो मैम नहीं बोला, सॉरी मैम, वो मैं बोला मैं पिछले बार भी
15/1/2025
यस मैम,
आपका क्लियरेंसी नोटिस ही एक्सेप्ट।
आई एग्री मैम, दैट्स नॉट, ये बोल रहा हूँ पिछले
कंसेंट का कोई जरूरत नहीं है।
क्या
आप बोलते हैं कंसेंट का जरूरत
नहीं, बिना कंसेंट के ऐसा नहीं हो सकता है।
बिना कंसेंट
देखिए अपीलान को तैयार होना पड़ता है केस के लिए।
यस मैम, सुबह में खबर इनको
अच्छा,
मैं
कोई बात नहीं,
ठीक है, सॉरी मैं नहीं किया, सॉरी।
इतना ही बोल रहे हैं ये कि इसको नेक्स्ट वीक रखने के लिए।
जैसा मैम,
इसको
इसलिए
नेक्स्ट
मैम
वीक रख देते हैं।
इनको कॉस्ट पर किया गया था और उसके बाद 6 महीना का डेट लगाया गया था, इसीलिए मैम और ने मेरे को बोला
एक सेकंड, ऐसा बात तो नहीं है।
यस मैम,
हाई कोर्ट
देखा
के लिए वकील क्यों लड़ रहे हैं?
6 महीने का डेट इनके रिक्वेस्ट में नहीं लगा था, हमने खुद से लगाया।
सॉरी मैम, कोई बात नहीं।
ठीक है,
ठीक है मैम।
तो आप इन पर नहीं दोष दे सकते।
नहीं सॉरी मैम,
इनके रिक्वेस्ट
हम लोग
कोई बात नहीं,
वकील हैं, हम लोग
कोई
क्या
बात
लड़ाई?
नहीं, हम लोग क्या
He has answered to me, that was not.
उनके एंजाइटी आप समझिए, बोकारो से आ रहे हैं, ठीक है, लिटिगेंट इज इनकरिंग एक्सपेंसेस।
लिटिगेंट देखने में बैठे हुए।
कोई बात नहीं, इसीलिए लिटिगेंट को मत सुनाइए।
नहीं वो नहीं, मैं बोल रहे हैं सो बोल।
लिटिगेंट इज इनकरिंग एक्सपेंसेस टू ब्रिंग यू हियर, तो थोड़ा एंजाइटी है। आप लोग यही रहते हैं, आपको नहीं फर्क पड़ता, आज नहीं होगा तो 1 हफ्ता बाद हो जाएगा, लेकिन इनको फर्क पड़ता है।
नंबर ले ले हम लोग का, हम लोग से बोल दें।
आप कब करेंगे बताइए सर? नेक्स्ट वीक करना है ना आपको?
किसी दिन रख दिया जाए।
आप कुछ नोट्स वगैरह बनाए हैं?
नहीं बना।
आप बनाए हैं?
जी मैम बना।
कहाँ हैं? दीजिए।
दे देंगे हम, लिस्ट में दे देंगे मैम, मैं भी देखेंगे। मैं बना कर रखा हूँ।
बना के लाए हैं तो दे दीजिए ना, कोई लुका छिपी थोड़ी है।
नहीं लुका छुपी नहीं है।
हाँ तो आप पढ़ के आएंगे ना। कितने विटनेस हैं इसमें?
3 विटनेस है। प्लेंटिव के 2 विटनेस हैं, 3, और हमारे 2, जो डिफेंडेंट थे वही बस, और कोई नहीं।
ठीक, ज्यादा लंबा चौड़ा है
नहीं, ज्यादा लंबा चौड़ा नहीं मैम, नट सेल में कहीं इसमें कुछ है ही नहीं मैम। मेरिट पे बोलेंगे तो मैम आधा घंटा सुनेंगे, आधा घंटा सब डिसाइड कर देंगे।
अब इतने दूर से आए हैं, थोड़ा 2 मिनट आप हमको, ज्यादा नहीं, 5 मिनट 7 मिनट आपको देंगे
जी।
आप हमको बताइए कि नटशेल आपका क्या केस?
नट सेल में
आप
केस
कौन है? पेंटिंग है?
हम डिफेंडेंट नंबर, इसमें लोअर कोर्ट में डिफेंडेंट नंबर 2, 1 और 2 हम है, और प्लेंटिव हमारे ऑल ब्रदर हैं। प्लेंटिव नंबर 1 और प्लेंटिव नंबर 2 वो गोतनी है, और दोनों का गोतनी के नाम से अलग-अलग जमीन है मैम। 2.5 डिसमिल उनका है प्लेंटिव का, और मेरा 21.5 डिसमिल जमीन है। इनका कहना है कि ये ज्वाइंट प्रॉपर्टी से खरीदा गया है, इसलिए इसमें शेयर चाहिए मेरा। हमारा अलग एंजॉयमेंट है, मेरा अलग है, सब चीज शुरू से सेपरेट, कहीं कुछ नहीं है। हमारे नाम से अलग म्यूटेशन है, हमारा अलग कागज है, हमारा अलग घर बना हुआ है। ये खाली बदमाशी करने के लिए मैं यहाँ
ऐसे शब्दों का प्रयोग ना करें।
तो ये करने के लिए बस हमको हरास करने के लिए खाली केवल बस कि यहाँ के वहाँ फंसा दिए लाके। मैं गोतनी से कोई पार्टनरशिप हो सकता है क्या? लंदन प्रिंट बता दे मेरे को, गोतनी से पार्टनरशिप हो सकता है? दोनों का अलग अलग है मैम, हमारा कहीं जोड़ ही इनसे नहीं है। और इन्होंने अपने कहा है मैम, इनके क्रॉस में मैंने पूछा, इन्होंने कहा कि अपना अपना इनकम और अपना इनकम से खरीदेंगे। इन्हीं इनका क्रॉस, मेरा कुछ नहीं है, और सब गवाह इन्हीं का है मैम। मेरा तो केवल डिपेंडेंट, हम लोग दोनों को बनाए हैं पति पत्नी को डिपेंडेंट, वही पति पत्नी का हमारा क्रॉस हुआ, और कुछ नहीं है। हम कागज देख रहे थे, इन्हीं का कागज सर सबमिट किया हुआ, हमारा जो मैम डीड वगैरह सब यही लगा है, हम तो कोई कागज नहीं लगा है मैम। और लंदन ट्रायल कोर्ट ने स्पष्ट लिखा है, एकदम क्लियर कट एकदम, कि इसमें कहीं कोई ये नहीं है। और जस्ट खाली बस हमको परेशान कर लेके, चूंकि हमारी बेटी केवल है, ये चाह रहा है कि जल्दी हम हड़प ले लेके निकल जाए, इसी फेरा में हमको तंग किए जा रहे हैं। नहीं तो इनसे कोई लेना देना मैम नहीं। मेरा अपना म्यूटेशन, मेरा अपना ये, मेरा अपना इनकम, मेरा अपना सब चीज है शेयर।
क्या सोर्स ऑफ इनकम है आपका?
मेरा हमारा बिजनेस है, व्यापार है।
ठीक है, सोमवार को सुनिए, ठीक है? आप लोग आ जाएंगे सुबह 10:30? 12:30 तो नहीं हो पाएगा ना?
1 घंटा में तो बोल रहे हो ही जाएगा।
आप तो 1 घंटा नहीं लेंगे ना?
नहीं हम नहीं लेंगे।
वही तो
मेरा एडिशनल एविडेंस के लिए एक पिटीशन है, वो हम प्लेस करेंगे, उसको कंसीडर
आइए आप फाइल किए हैं
जी।
एविडेंस के लिए।
इट इज ऑन बोर्ड।
क्या है आपका एडिशनल एविडेंस? आपने देखा है?
हाँ देखा है, जवाब
इसका जवाब दे दिए हैं?
नहीं, जवाब देने में हम 2 मिनट से तो उस दिन जवाब दे देंगे, ये बोल रहे हैं।
नहीं आप राइटिंग में जवाब।
ठीक है, राइटिंग दे देंगे।
आप
इन्होंने कहा है मैम ना, हमारा ज्वाइंट प्रॉपर्टी जो है, इनका आधा जो है जमीन, और मेरे आईसीआईसी बैंक है वहाँ टेनेंट, तो आधा मेरे को पैसा देता है, आधा इनको देता है। हमारे एरिया का हमको पैसा देता है, और ज्वाइंट एक ही डीड है, जो लीज होता है, लीज एग्रीमेंट, एक ही लीज एग्रीमेंट दोनों हम लोग अपनी का है। उनको उनका शेयर मिलता है, हमको अपना शेयर मिलता है। और ये बड़ा कंसीडर किया गया था, लोअर कोर्ट में डाला गया था, अभी फिर रिन्यूअल हुआ, उसके बारे में ये बोल रहे हैं,
मतलब
दैट इज कंटिन्यू चल रहा।
ये जो डॉक्यूमेंट है
जी।
जो एडिशनल एविडेंस के लिए बोल
जी
ये ट्रायल कोर्ट में एविडेंस में आ चुका है।
यस आया हुआ है, ये रिन्यू हुआ है बस, अभी नया बात ये है कि रिन्यू हुआ बस।
अच्छा, इट इज द सेम थिंग।
ये सेम दैट सेम, केवल रिन्यू हुआ है।
ओनली रिन्यूअल है।
यस यस यस।
व्हिच इज दैट एग्जिबिट? व्हिच इज दैट एग्जिबिट ट्रायल कोर्ट का?
That document was
आपको बिना सुने थोड़ी ऑर्डर करनी, अभी इतनी दूर से आए थे तो सुनना। बताइए आपका कौन सा एग्जिबिट है वो?
मेरा एग्जिबिट नहीं, इन्हीं का पेपर दिया हुआ।
कौन सा
मेरा कुछ है ही नहीं का डॉक्यूमेंट।
एग्जिबिट कौन सा?
बता दे।
ये एग्जिबिट 3
जी
सर्टिफाइड कॉपी ऑफ द लीज डीड।
जी यस। केवल मैम अभी रिन्यूअल हुआ,
Yes.
और कुछ नहीं।
इसमें डीड में लिखा हुआ है कि का ये पहले ये रिन्यूअल डीड है। इट मस्ट बी रिटन।
नहीं नया तो उन्होंने नहीं लगा, नया तो आई अभी डाला उसमें ये किया है मेंशन, वो अभी रिन्यू नया बात है कि रिन्यू हुआ बस और कुछ नहीं। सेम पार्टी है मैम, सेम डीड है, सेम ये है लीज।
ये तो फ्रेश डीड लग रहा है, रिन्यूअल डीड नहीं लग रहा।
इसमें जो लगा हुआ पहले से जो वही मैं बोला मैं पहले से लोअर कोर्ट में जो लगा हुआ था ना, जो ट्रायल हुआ इसमें वो लीज पुराना लीज था, अभी जनवरी में जाके वो रिन्यूड हुआ है।
रिन्यूड नहीं है, ये फ्रेश लीज है।
मतलब वही रिन्यू फ्रेश मतलब रिन्यू होता है ना, तो फिर नया लीज बनता है। जैसे सेम होगा मैटर, सेम पार्टी, सेम ये सेम बैंक, तो रिन्यूअल जैसे 11 महीना के बाद बैंक होता है तो रिन्यूअल होता है।
आप इसका एक फॉर्मल रिप्लाई फ्राइडे को फाइल कर दीजिए।
ठीक
आपको जो बोलना है
ठीक
एडिशनल एविडेंस है ना, इसको ऐसे इग्नोर नहीं कर सकते।
कोई बात नहीं।
So according to you, even if it is taken into consideration, it will make no difference,
Yes
right?
yes
The terms and conditions are the same,
same
and this document is otherwise not in dispute.
yes
तो आप इतना चीज तो बोलेंगे ना,
जी
ये तो एडिशनल एविडेंस का रिबटल करने चाहिएगा तो फिर भेज देंगे ट्रायल।
नहीं कितना बोला
अगर आप एडमिट करते हैं डॉक्यूमेंट को तो आप बोल देंगे देन वी विल सी द डॉक्यूमेंट व्हाट इज टू बी डन।
यस एडमिट करते हो है ही मैं
आप एफिडेविट फाइल करना पड़ेगा,
ठीक दे
आपके ओरल एडमिशन से नहीं चलेगा।
नो प्रॉब्लम दे दो।
डिस्प्यूट होगा तो एविडेंस हम यहाँ पे नहीं लेंगे।
नहीं डिस्प्यूट नहीं है।
ठीक, आप उसका रिप्लाई फाइल करें।
ठीक
आपका आना सफल हो गया ना?
यस
एफए नंबर 175 ऑफ
एक
2024।
मिनट टाइम में
हाँ
अब जानते होंगे हमारे कली बोकारो से रोज आते रहे पिछले 25 साल, अभी बेचारे ओल्ड एज हो गए तो यहाँ फिर रांची शिफ्ट।
कौन?
मिस्टर बीपी सिंह के साथ थे, क्या नाम है उनका? हम लोग उनको बाबा
तिवारी सर,
तिवारी,
यस,
रामाकांत तिवारी,
रामाकांत तिवारी, यस।
इसलिए बोकारो बहुत दूर नहीं है, बाय ट्रेन इट टेक्स ओनली फ्यू
कोई
आवर्स।
बात नहीं, मंडे को आ जाएंगे सर।
हाँ।
आइए का जवाब तो फाइल करने
हाँ,
में। अगर एडमिटेड डॉक्यूमेंट है तब तो कुछ चक्कर ही नहीं है, कोई
कोई
प्रॉब्लम
चक्कर
ही नहीं है। अगर डिस्प्यूटेड है तो एडिशनल एविडेंस तो हम यहाँ नहीं देंगे।
नहीं मैम, डिस्प्यूटेड नहीं, एडमिटेड।
IE number 14011 of 2025 in FA number 175 of 2024. This interlocutory application has been filed seeking to adduce additional evidence. The learned counsel for the respondents submit that he shall file a response to the additional evidence to the interlocutory application by Friday, and has prayed that the matter be kept for final hearing. He has also submitted that he comes from Bokaro, and if the date is fixed and the case is taken up, it will be convenient to him and his staff. With the consent of the counsel for the parties, post this case for final disposal on Monday to be taken up as the first case. Thank you.
ट्रेन 30 में जो बहुत कोर्ट में दौड़ना पड़ता है, अभी भी दौड़ के 24 नंबर का
आ गया।
11:30 का ट्रेन।
Item 3, second appeal 80 of 1996.
आपका जूनियर मेंशन कर रहा है उसको दान,
हाँ बस आप
उसको दान दीजिए।
अभी को आना सोच रहा है, उस ऑन द
अच्छा
वे।
कोई बात नहीं, आप हमको ये बताइए कि आपके उस मैटर में अदर साइड
हाँ,
केस इज अदरवाइज रेडी।
yes, yes, it is.
अदर साइड कौन है, उनसे कंसेंट
रोहित रॉय लॉर्डशिप आई जस्ट ट्राइड टू कॉल हिम।
वो तो कभी कंसेंट मना नहीं करते।
हाँ, मना नहीं करेंगे, हम बात करके देख लेते हैं। अदरवाइज 215 लॉर्डशिप आई विल देयर।
हाँ।
अदरवाइज वहाँ हम रेट इशू करके सिलसिला के रिपोर्ट मांग लिए और कल ही डेट है, तो
We'll see that.
2-3 दिन में किसी दिन भी अगर मिले।
We'll see.
This case
सवा 2 बजे आ जाएगा।
but the order number 5 lordship in this case, the substantial question of law was framed.
Order number 5.
Lordship 25/11/1999.
हाँ yes.
Whether the courts below erred in law in ignoring assessment of rent under section 6 of the Bihar Land Reforms Act 1950 in the name of the defendant appellants. We are lordship defendant appellant appellant.
अच्छा वो आपने फर्स्ट अपील का ऑर्डर देख लिया? वो अपलोड हो गया कैसे?
Yes, सारा बन we got the net copy we have received. All are satisfied.
No, I don't know. लेकिन वो एक मतलब anybody might like to challenge it, इसलिए हम ऑर्डर हो गया।
अभी तक तो from all concerns what we have.
आप ही हैं सर उसमें?
हमें कहीं
सारा वाला में?
नहीं
अच्छा, वो है कि काफी कंटेस्टेड केस था तब इनसे थोड़ा ठीक है। हाँ बताइए।
हाँ, तो this is the substantial question of lordship.
आप कौन हैं?
We are defendant appellant.
डिफेंडेंट। Suit was decreed.
Suit was decreed, the appeal was also dismissed.
What was the suit for?
Lordship.
इसका रिकॉर्ड।
The prayer lordship at the time. I will conclude होगा इस process में हम
कोई बात नहीं, अब शुरू करिए।
lordship.
हम कहाँ किसी को बोलते हैं कि आप कंक्लूड
नहीं बिल्कुल. It is better to एक बार extra एक हो जाए, but proper identification should be there lordship from both sides. Rent का पैरा page 6 है.
प्लेन देखें,
हाँ, rent का वहाँ से prayer हम बता देते हैं.
इसमें तो डिक्टी लगाए होंगे ना क्या?
हाँ हाँ.
उसमें होगा? नहीं है, डिक्टी नहीं लगाए। हमारे हाईकोर्ट रूल्स में ट्राई कोर्ट का डिग्री लगाना मैंडेटरी है।
मैंडेटरी है, हम लोग नहीं लगाते तो डिफेक्ट निकलता है। लास्ट
नहीं,
20
नहीं
ईयर से
निकलता।
पता नहीं कैसे
बहुत सारे केसेस में ट्राई कोर्ट की डिग्री नहीं लगती सेकंड अपील में।
असल में 96 का है पता नहीं।
इधर में हो गया है टाइप
सब
कॉपी
लोग ज्यादा
नीचे
बताएंगे। हाँ
टाइप कॉपी नीचे लगाएगी
नहीं
समझा असेंबल करके पेज 5 है पेज 10 है सबका टाइप कॉपी लगेगा तो सब नीचे रहेगा।
सर हम पूछ रहे हैं कि ट्राई कोर्ट का डिग्री नहीं लगता है सेकंड
डिग्री तो अपील में तो लगता ही लगता है।
फर्स्ट अपील में तो हम देख रहे हैं, सेकंड अपील में नहीं रहता है डिग्री।
हाँ रहना चाहिए
दोनों रहना चाहिए ना।
हम लोग प्रैक्टिसिंग सिंस 1999 उस समय से हुजूर हम लोग देख रहे
हम लोग तो
थे।
हमेशा लगाते थे, लेकिन
अब सर
ये
लोग
सारे इसमें देख रहे हैं कि नहीं।
सर को मैं इसलिए कह रहा हूँ कि पहले के हैं, पता नहीं उस समय क्या था, क्योंकि 96 का है, हम लोग के पहले का है। लेकिन एज पर हाई कोर्ट रूल्स जजमेंट एंड डिग्री बोथ आर रिकॉर्ड।
चलिए यस
Relief A at page 6 that it be adjudicated and declared that the sued land it is Rayati land of the plaintiff, settlement standing in the name of Lal Mohan Prasad. The name is important. And in their lawful position. Secondary lordship, that's an important issue. Relief. That the position of the plaintiff be confirmed, and in case the plaintiff are deemed to be out of position in the eye of law, the plaintiffs be delivered possession of the suit land through the process of. Now, lordship, by this relief, we could gather, lordship, that there is some dispute with regard to possession also. It is half-heartedly admitted that they are out of position. Now, lordship, what is the case? The plaintiff's case, lordship, in short. The land lordship originally was the Gair Majurwa land Malik, Gair Majurwa Malik land of the Deeden landlord. The dependents are the descendants of the Deeden landlord. It was recorded in the name of Swambar Tiwari. Plot is 773. Total area 48 decimals, out of which lordship, as per the plaintiff, it was stated that the 8 kattha lands was 8 kattha of land out of the said plot was settled lordship in favor of one Haridas in the year 1925, that is 28/10/1925, and this Haridas has sold to one Gaya Prashad, who happens to be the pleader. It is important not to why I am specifying pleader, because later on Lordship will come to know what has happened in this case. And this Gaya Prashad has purchased the said property in the name of his minor son, namely Lal Mohan Prasad. That is by registered settlement and deed lordship, that is 28/7/1926. It is also alleged that the Jamindari rent receipt was granted to them. Thereafter, lordship, sometime the rent was not paid, and therefore one rent suit was also filed. That is rent suit number 506 of 1943. They have also, lordship, pleaded. The return was filed under section 3 of the BLR Act, and the Gaya Prashad was shown as a rayat of the suit land. Now, lordship, from here the story starts. Although they say that the rent was filed by the return was filed by the landlord, and the Gaya Prashad was shown as a landlord, but lordship, the demand was not lordship
shown as ready.
shown as a year, but the demand was not opened in the name of Gaya Prashad or his son, because actually it was purchased in the name of the minor son Lal Mohan Prasad. From here the story starts. And now the further pleading is that since the defendant was the Mukhya of the Panchayat, it was manipulated by him, and the rent was assessed in the name of the defendants, the contesting defendants.
When was the suit filed?
Suit was filed, Lordship, in the year 1978. 86-78.
78.
It was decided in the year 1987. The appeal was filed in 87, that was decided in 96, and thereafter since 96 this second appeal is pending.
Okay.
The
Then this particular act of not opening the Jamabandi in the name of the Gaya Prasad or his son was never challenged.
and वो भी लिखा है. They said that one miscellaneous case was filed after this opening of the rent directly before the AC. अब यहाँ से जो सारा कुछ आ गया. And the AC
यहाँ से पढ़िए आप इसको पैरासेलेंस
से पढ़ दो.
हाँ पढ़.
That the revenue authorities concerned were requested many times for opening the demand of the suit land, but there was no response communicated to the aforesaid Sri Gaya Prasad or Sri Lal Mohan Prasad or any of the plaintiffs. Ultimately, a petition dated 15/9/1969. This is important. On behalf of Lal Mohan Prasad, in whose name the sale deed stood, was filed before the CO Dartinganj. The CO, without going through the requisite formalities of law, rejected the petition for opening the demand in the name of Lal Mohan Prasad on the ground that the rent of the suit land has already been assessed in the name of the defendants by order dated 5/5/1970 and 28/5/1970, passed in Revenue Miscellaneous Case number 1 of 1970-71. In course of which the case of the plaintiffs could know that the defendants have got assessment of rent of the suit land in their favor unlawfully behind the back of the plaintiff, Shri Gaya Prasad or Shri Lal Mohan Prasad, and without any notice or intimation to them, in spite of the fact that Shri Gaya Prasad was shown as Rayat of the suit land by the defendants in their return filed under Section 3 of the Penal Act. That on behalf of the aforesaid Shri Lal Mohan Prasad, the petition was filed before the AC. Now this is important, Lordship. The AC Palamu against an order of the CO dated such and such in Revenue Miscellaneous Case number such and such, which was registered as Revenue Miscellaneous Case number of 1970-71. The additional collector, after going through all the formalities of the law and hearing the parties, including the defendants, was pleased to set aside the order of the CO with the directive to open the demand in the name of the aforesaid Sri Lal Mohan Prasad by his order dated 21/12/1972. The defendants went before the commissioner against the aforesaid order, which was registered as Revenue Mutation Case Appeal number such and such. The commissioner, by his order dated 21/2/1973, also after hearing the parties and going through the formalities of the law, dismissed the appeal, confirming the order of the additional collector Palamu. The defendants moved against the order of the commissioner in the revision in the Honorable Board of Revenue, which was numbered as the Board Revenue Case number 103 of 1973. And under misconception of law and facts, the board by its order dated 21/12/1975 was pleased to set aside the orders of the commissioner of the Shotnagpur division, also for the additional collector Paran. Now, Lordship, since they have not stated anything, the Board of Revenue came to a finding that after the order of the circle officer, the AC did not have the jurisdiction. It was the LRDC, and on that point, Lordship, the entire order of the AC was set aside. And after that, Lordship, they have filed this. That though the order of the Board of Revenue in no way affects the title and position of the plaintiff, but with a view to get the matter settled once for all, the plaintiff feel it necessary for filing this suit. That the aforesaid Sri Gaya Prasad died leaving behind 5 sons, namely.
We are concerned with only this part of the claim.
Yes.
Technically, we are concerned with only this part of it.
Yes.
Considering the substantial.
Yes. Because since there was an assessment.
Let's have the sequence like this. The landlord, they file their return. Landlord are the defendants.
The ancestor of the original landlord, descendants of the original landlord. Swayamvar Tiwari के descendants हैं, अभी भी defendants.
अच्छा, defendants are the descendants of original landlord.
Swayamvar Tiwari.
That's right. Okay. The landlord filed his return under section 3B. Disputed or undisputed?
हम वहाँ तक नहीं पहुँचे हुए। I think it is disputed since we have to see whether any exhibit is there or not. हम उसको देख नहीं पा रहे हैं।
As per this.
Yes, as per this they say that
3B में फाइल किए।
हाँ,
इसमें plaintiff को दिखाया as the rear.
हाँ,
Rear, purchaser from the rear.
purchaser.
But rent assessment was not done.
Not under section 6.
It is one thing to say that rent assessment was not done in favor of the rear or the successor in interest. It is another thing to say that rent assessment was not done at all.
Not done at all.
Not done at all.
Yes.
Okay. So it was not assessed in name of anybody.
Yes. Thereafter, what happened? Till 1968, no assessment was there in any person's name.
That's it.
Since we were the Jamindar, we filed an application for assessment of rent. That was done in our favor. In the meantime, since it
which is that order by which it was done?
That is Lordship the.
Because this particular narration is not reflecting that.
ये हमारा WS में है.
आपके WS.
And that is an admitted fact against which Lordship they have filed an appeal. Religion Board of
उसी से शुरू.
उसी शुरू.
जब आपने फाइल किया तो
हमारे नाम पे हो गया.
आपके नाम पे हो.
अब हुआ क्या उसको जो बेसिक लोकल थिंग्स है वो तो एक खलिहान और निक्सार था. हमारे घर के सामने का खलिहान और निक्सार जमींदार का था चुकी. और ये इनका कहते हैं कि इनका भी एडजेसेंट है वो इन्हें खरीद लिया था या इनके वो खरीद लिए थे and he was a leader of that place. Therefore when they came to know कि ऐसा हो रहा है इनके नाम से एसेस हो जाएगा तो ये भी अपना असेसमेंट के लिए डाला which was ultimately rejected by the circumstance.
When this particular assessment was made in your favor,
yes,
he was not noticed.
As per them, he was not noticed.
He was not noticed, but a registered sale deed was standing in his name.
Yes, that is very clear.
Who was in possession?
We were in possession being.
What is the finding of both the courts?
उस पॉइंट पे तो सर मायने
Because possession पे कोई substantial question of law नहीं है.
बिल्कुल.
हाँ. Possession पे कोई substantial question of law नहीं है. तो possession is important.
Yes. वो तो देखना जरूरी है.
ठीक. समझ गया आपको WS बताइए. Only one WS?
Lordship. I am reading from paragraph 4. The statement made in para 1 of the plaintiff is not only correct. Although the plot number 733 and area of 48 decimal was recorded Gair Mujibur Maliki, but the true fact is that the entire area of 48 decimals was used as Kalyan by the ancestor of the defendant number 1 to 4 as the landlords and was recorded as such during the last service agreement. The entire plot was also used by the then landlord as his niksan, because adjoining it was the defendants have their ancestral house and it is as such even now, and indeed there has been no change whatsoever except that there had been some construction made up to foundation level 4 years back. Cattle is always tied there since long time. The statement as made in para 2 is not admitted because documents said to have been executed in 1925 in favor of the Haridas was not made in their presence, nor they had any knowledge about such document in favor of the Haridas. These defendants do not admit that Haridas was ever indicted on the land as stated in the para of the people. So far as the defendants now know, there had been no such sale or lease in favor of Haridas. Haridas was never in possession as alleged, and even if any such document is produced, the same was forged and never acted upon. It is also false to say that the name of the Haridas was never mutated in the landlord's sarista, nor he was ever accepted as tenant, nor he was ever came in possession of the portion of this plot. It is false to say that the plaintiff's father constructed a boundary wall in the plot as falsely alleged in the plea. Neither he had constructed any house. or any pakka wall on the land. The entire statement as made in para 2 is denied. The allegation is that the said Haridas exercised his position without any objection from any other quarter does not arise in the face of the fact of the stated above. So far as the para 3 of the plaint is concerned, the same is denied. It is also denied that Shigaya Prasad had purchased the suit land from Haridas. It is also untrue to say that any such land was ever purchased by Sri Gaya Prasad in the name of his son Lal Mohan Prasad. It is false to say that the so-called purchaser of the land came in possession of the land. It is false to say that any brick wall compound was constructed by the Kacha wall and a Kacha wall was converted into Pakka wall by the plaintiff's father. It is also false to say that he was in possession of the suit land even for a day. It is also incorrect to say that the name of the plaintiff's father was mutated in the office of the then landlord. It is also incorrect to say that any rent was realized from Shri Gaya Prasad and the rent receipt granted in his name for the suit land as alleged. There was never a kacha wall, nor it is ever made pakka. Indeed, there had never been any such wall. That so far as para 4 is concerned, the same is not denied, except this that Shiv Narayan Tiwari died leaving behind his only 3 sons, as stated in the suit para, but has other heirs are also not made party to the suit land, and therefore the suit is also liable to be dismissed for the non-joint domination parties. It is so far as para 5 is concerned, this defendant has got no knowledge that any rent suit was filed for the land, and the suit against the purchaser, Shri Lal Mohan Prasad, had stated in the para of the print. If there was any such suit, the same must have been for other lands or was a vexatious suit. The same was without any cause of action. On this, the Lal Mohan Prasad could have been sued if there was any purchase by them. Even if there had been any suit, it is not admitted that any such suit was for the suit land. It is admitted that the Sri Gaya Prasad, not having been a tenant of the suit land, could not have been sued for any areas of rent, if any, standing in the name of Sri Lal Mohan Prasad. These defendants do not admit any such degree, nor it is admitted that any decretal amount was ever realized or paid as stated in para 5 of the print. That so far para 6 of the print is concerned, the fact is stated in this para is not correctly made. It is in the first place, Sri Gaya Prasad was not the tenant of the suit land, and therefore the mentioning of his name as tenant for the land in the suit could not have been made as obviously as stated above. Sri Gaya Prasad was never tenant of the defendant's father or of the defendants. Therefore, the mentioning of the name of Sri Gaya Prasad as tenant of the defendant in the return was afterthought, and it is a manipulation. These defendants assert that they had never accepted Sri Gaya Prasad as tenant of the suit land. Even according to the plaintiff, Sri Gaya Prasad was not a tenant of the suit land, but according to the plaintiff, Sri Lal Mohan Prasad was the tenant. If Sri Lal Mohan Prasad was the tenant in possession, his name alone should have been shown in the return. In the first place, it is denied that Sri Gaya Prasad was ever a tenant of the suit land, and therefore the entry of his name in the return was purely a manipulation and motivated to make by influencing the alums of the office, and as such the plaintiff cannot derive any advantage of such wrong fabricated entry. On a spot inquiry by the revenue department, the event number 1 to 4 were found in possession of the suit land. The name of Sri Gaya Prasad was not entered in the demand register of the revenue office. In fact, there was a spot inquiry in presence of the plaintiff and their father by the revenue department, circle officer, and the plaintiffs or their father were never found in possession of the suit land. In fact, before the revenue office, who had made spot inquiry or evidentiary document or oral were given on behalf of the plaintiff to prove their possession. Obviously, because they had done. The allegation that the defendant number 1, Shri Ramdhani Tiwari, had been a Mukhya of the Gram Panchayat, an influential man, had hand in influencing the officers is false. The true fact is that Shri Ramdhan Tiwari was not a Mukhya in the years in question as falsely alleged. The name of Ramdhani Tiwari was shown in the demand register for the suit land in 1955-56 when he was not a Mukhya, para 7, is concerned, so far as the para 7 is concerned. The statement made in para 7 of the plaint is incorrect. In fact, at the time of opening of the demand, all parties concerned were present and the inquiry was held in their presence. The statement that the petition dated 15/9/1969 was filed and behalf of Sri Ram Mohan Prasad was filed before the Circle Officer Dartinganj was true to this extent that such a petition was filed by Sri Ram Mohan Prasad. This was the first time that any claim was laid by Sri Ram Mohan Prasad for the suit land. Prior to this, there was no such claim ever put by Sri Ram Mohan Prasad, in whose name the land in suit was purported to have been acquired in 1926. As submitted above, there there had never been any such occasion as alleged in the petition, nor he had got any position either through his father or through himself. This was the first time when Sri Mohan Prasad claimed the suit land, alleging that in fact he was a tenant of the suit land. He never admitted that suit land was purchased by his father. Anyhow, this matter was fully acquired into and his claim was found to be untrue and baseless. The plaintiff had full knowledge about the assessment of the rent for the land in suit in favor of the defendant prior to this. It is false to say that the plaintiff would know of the order of miscellaneous case number 1 of 1970-71 for the first time. The order passed in the above miscellaneous case was an appealable order, but after limitation period, a false move was made for setting aside the order of the Revenue Department after assessment of rent was made in favor of defendant number 1 to 4. But from the perusal of this statement as made in para 8 of the print, the order of the assessment was already made in favor of defendant number 1 to 4, but notwithstanding this, no step was taken either by Sri Gaya Prasad or Sri Lal Mohan Prasad to go to the appeal as provided under the law. But he went direct to the additional character against the above order without any justification and against, indeed, the additional character had no jurisdiction under the provision of law to admit and decide the matter to which he had no jurisdiction. The order of the learned additional character was set aside by the order of the Honorable Board of Revenue, which on hearing both the parties had set aside the order of the learned additional character as perverse, illegal and without jurisdiction. That final order of the Honorable Board of Revenue or assessment of rent under Bihar Land Reforms Act cannot be questioned by the civil court under Bihar Land Reforms Act, and similarly, order passed in favor of the defendant number 1 to 4 under the provisions of the Land Reforms Act in assessing rent in their favor cannot be questioned, as this is hit under the several provisions of the Bihar Land Reforms Act. So far as the statement in para 10 is concerned, it is admitted that the first time Gaya Prasad has claimed right title and possession of the suit land on the basis that the same was purchased in the name of his elder son, Benami, and thereafter his elder son Lal Mohan Prasad had alone claimed the suit land before the circle officer. It was a contradictory claim. Sri Lal Mohan Prasad had claimed the right and possession alone, and the question of deriving any right by Sri Gaya Prasad cannot be true. And in this view, as the matter has also the entire suit is fit to be dismissed. The other fact in para 10 are not admitted.
That's right, we have seen. So what is the issue framed by the trial?
Lordship. Page internal page 12 Lordship trial project. Para 9.
Just para 9.
Lordship.
Internal page?
Internal page 12 Lordship 1.
Page number 10.
Lordship 1.
Just इंटरनल बेस 6 में, मतलब ट्रायल कोर्ट का जो ओरिजिनल जजमेंट, फोटोकॉपी नहीं आया होगा ना, टाइप कॉपी आया होगा इसमें।
पैरा नंबर कितना?
पैरा 9।
यहाँ चूंकि सर्टिफाइड कॉपी ले आपका करा सकते हैं। पैरा 9 अच्छा।
वर्षन में सर्टिफाइड कॉपी ठीक से पढ़ना नहीं है, थोड़ा सा पेट।
Is the suit maintainable as claimed? Have the plaintiff valid cause of action to bring the suit? Is the suit barred by law of limitation and adverse position?
They are concerned with issue number.
Not sure. 6, 7, 8 Not No, 7. 7, 8, and 8 का 2 बार बोल रहा है. In my copy.
So we are concerned with issue number.
7, 8 में हम पढ़ते हैं तो शायद सेम अलग है.
हाँ.
Was the suit land settled to Haridas?
Yes.
By the ex-landlord Swambar Tiwari, the ancestor of the contesting defendant number 1 to 4, and did he came in position of it? Position का issue है.
That's it. I think.
Because वहीं से position आ रहा है.
8.
The suit land purchased by Gaya Prasad in the name of his minor son Lal Mohan Prasad by registered sale deed date such and such from Haridas. If so, did he acquire right title and interest over the same, and did he came in possession over the same? दोनों में possession.
Basically तो issue number 7 ही है.
हाँ. अगर 7 का हो गया तो फिर 8 का हो.
Substantial question तो इसी से आंसर होगा 7
Yes,
से.
yes, yes.
ठीक है. Issue number 7 पर.
7 और 8 जो साथ में डिसाइड हुआ.
ठीक है. It starts from which page?
अभी 6 पढ़ो ना. हाँ 7 हमारा पेज 21 है जरा. पैराग्राफ 13 पे है.
Issue number 7.
Just part.
Issue number 7.
No.
हाँ.
The plaintiff have clearly asserted 6 को भी जो लॉ डिसाइड किया.
6 को भी 6 में ही डिसाइड किए हैं. Therefore, on the basis of discussion made above, I come to a finding that the suit land was settled to Haridas.
Yes.
And he was put in possession.
6 से पढ़ते हैं.
6 से पढ़िए. वो थोड़ा सा इधर-उधर ये है.
ये पैरा 11 में 6.
पैरा 11.
Issue 1.
हाँ. पैरा 11. पढ़िए.
Has the suit अच्छा properly valued करना है. ठीक है. 6.
It is admitted.
It is admitted case of the parties that the suit land, which is the part of the survey plot number such and such, area 48 decimals, stand recorded as Gair Mazrua Mali in the last cadastral survey in the name of Swambar Tiwari. Having interest to the extent of 10 pi and odd, the plaintiff has specifically pleaded that the ex-landlord Swambar Tiwari be by registered patta dated 28/10/1925 has settled the suit land, that is 8 kattha of the land, in survey plot number 733 of the
This was a registered patta.
Registered.
In whose favor?
In favor of Haridas.
Haridas.
Registered patta, that is 8 kattha of land in survey plot number 733, village Redma, in favor of Haridas on yearly rental of ₹6, and put in settling in possession thereof, who built the kacha house and dug kacha well thereon, and his possession without any interference from any quarter. The contesting defendants in reply to this allegation have said that they are not aware of such settlement, and if there is any such document, the same must be forged and not acted upon. According to them, the suit land was never settled to Haridas and never put in possession. But the plaintiffs have filed the original settlement deed referred above, which has been marked as Exhibit 5. On going through the settlement deed, it appears that a permanent settlement has been made in favor of Haridas, and he was put in possession over the same. the contesting defendant number 1, who has deposed in court, has admitted that he has not made any search regarding the alleged settlement, nor he has any talk with respect to this settlement with his father, and he cannot even identify the signature of his father. This document is of the day 1925 and is registered one. Therefore, the prima facie it may be deemed that the document is genuine one unless and until the same is proved to be forged. Since the defendant have pleaded that the document is forged, one, therefore the eligible
onus was upon
onus
them.
was upon to prove that the said document is forged one, but the defendant have failed to prove it. Therefore, it must be presumed that Exhibit 5 is genuine document. If we go through the recitals made in the documents, we find that there is admission on the part of the ex-landlord Swayamvar Tiwari that the settlement is clear.
Mokarar, Swami, Kabal, Intikal, Bad, Basram. For Settli as well as his views.
For Settli as well as for his heirs. काबिल इंतकाल, अच्छा इंतकाल के बाद भी उनके बाल बच्चे का
inheritable right.
Yes. The settler or his heirs subject to the payment of rent and cess payable from time to time are at liberty to cultivate or use the land in whatever manner they like. There is clear recital that the condition of the deed is on the binding on the heirs of their parties and their heirs. The learned lawyer for the defendant has submitted that Exhibit 6 goes to show.
Exhibit 5.
Exhibit 5 goes to show that it is not a royalty settlement, but it is a settlement of tenure holders' right. He went to argue that on this basis, the mention of the term Mokarari in Exhibit 5 and in support of his submission, he has placed reliance reported in AIR Calcutta 1926 page such and such, in which it has been held that if a grant be made to a man for indefinite period, it ensures, generally speaking, for his lifetime and passes no interest to his heirs unless there are some words showing the intention to grant dash interest for eligible. He has also placed reliance upon the ruling in AIR such and such Calcutta, also in which the same point on the same point. He has made an attempt to argue that if the settlement indeed was executed in favor of the Haridas, it must be valid till the life of Haridas only and cannot be transferred his interest to anybody. If we go through the ruling, it is crystal clear that ordinarily the settlement is valid till the lifetime of the grantee unless there is some recital in the settlement deed intending to create interest in the legal heirs of the settlee after his death. I have already mentioned the recitals made in this settlement deed, Exhibit 5. If it is stipulated that the settlement is valid to the settlee as well as his legal heirs, one after another, subject to the condition of payment of rent and cess. It is also stipulated that the settlee or his legal heirs shall be at liberty to utilize the land in whatever manner they like to do so. Therefore, I find that there is no merit in the submission of the learned lawyer that the settlement, if at all, has lapsed after the death of Haridas. On summoning of the oral and documentary evidence, I find that the plaintiff have been able to prove that the ex-landlord, Swayamvar Tiwari, ancestor of the contesting defendants, had made settlement to the suit land to Haridas and has put him in possession over the same. On the contrary, the defendants have failed to prove that the Haridas was never put in possession. The defendant number 1 who is DW1, appears to be aged about 5 years only at the time of the said settlement because of the date of his evidence, that is August 1985. His age has been assessed as 65 years only. Therefore, in the year 1925, he must have not been more than 5 years. In cross-examination, he has admitted that he has not made any inquiry about this settlement. Therefore, he is totally incompetent to say that Haridas was never in possession of the suit land. On the other hand, Exhibit 6, the sale deed executed by Haridas, there is stipulation that he has constructed a kacha house and kacha wall in the suit land. Since Haridas has already died, his aforesaid statement goes to show that actually he remained in possession for about 1 year. Therefore, he had sold the land by executing sale deed Exhibit 6. There are overwhelming evidence, oral as well as documentary, which we shall discuss while deciding other issues to show that Gaya Prasad, the purchaser, has also remained in possession over the suit land. This is also a circumstance to show that if this Haridas was put in possession over the suit land, furthermore, there is admission of Swanvar Tiwari in the settlement deed Exhibit 5 that Haridas has paid him Nazrana and rent, and he was put him in position over the suit land. This admission in Exhibit 5 is also binding on the parties, that is the contesting defendants. Therefore, these contesting defendants now cannot be allowed to say that Haridas was not in possession over the suit land. Therefore, on the basis of the discussions of the above, I come to the finding the suit land was settled to Haridas and he was put in possession over the same, and the said settlement has created an hereditary interest too. According to this, the issue is answered in affirmative. Now, issue number 7. These plaintiffs have clearly asserted that Gaya Prasad has purchased the suit land in the name of his minor son, Lal Mohan Prasad, by registered sale deed dated 22/7/1926 from Haridas, and he came in possession over the same and constructed brick boundary wall and converted a kacha well into pakka well. It has also been asserted that the name of the Gaya Prasad was mutated in the office of the ex-landlord who used to realize rent and grant rent receipts in the name of the Gaya Prasad. And whenever there was arrears of rent, the ex-landlord realized the same by filing the rent suit. The Gaya Prasad remained in possession over the suit land till his lifetime, and after his death, plaintiff and performer defendants have succeeded and continue in possession over the same, who are the legal heirs of Gaya Prasad. The defendants in the written statement have denied all these allegations and have claimed that the suit land remained in their possession throughout and after vesting of the Jamindari, the rent has been assessed in their name. But if we go through the evidence of DW1, Ramdhani Tiwari, the defendant number 1, we find that he has admitted that he has granted rent receipts, Exhibit 7C, 7F and 7H, which are all in the name of Gaya Prasad. Further, we find that the defendants have filed certified copy of the Jamindari return, which was filed by these defendants under Section 3 of the Bihar Land Reforms Act, which has been used and which has been used by the plaintiff and has been marked as Exhibit 9. In this return, these very defendants have shown the suit plot in possession of the Gaya Prasad. The plaintiffs have filed the original sale deed executed by Haridas, the settlee of the suit land, which is dated by 1926. This sale deed has been marked Exhibit 6, which goes to show that the suit land was purchased by Gaya Prasad in the name of his minor son, Lal Mohan Prasad from Haridas. This sale deed is of unimpeachable nature. On record, there is no evidence from the side of the defendants to discard this document. While dealing issue number 6, we have already found that Haridas, issue number 5, we have already Haridas was settling in the suit land and from the ex-landlord and had an hereditary interest. Therefore, by the sale deed, Gaya Prasad has certainly acquired right title and interest over the suit land. The plaintiff have also filed the Jamindari rent receipts granted by ex-landlord, which has been marked Exhibit 7 series. The defendant number 1 admitted that the receipts Exhibit 7E, 7F to 7H has been granted by him. This proves beyond doubt that he has recognized Gaya Prasad, a tenant with respect to which the rent receipt Exhibit 7 series have been granted to Gaya Prasad. In the written statement, these defendants, there is no whisper that Gaya Prasad was a tenant under them with respect to some other land, other than the suit land. Actually, we find that this rent receipt exhibited Exhibit 7 series are for rupees 8 as rent, and in the settlement deed Exhibit 5 and in the sale deed Exhibit 6 also we find the same rent has been fixed. The last rent receipt is dated 26/6/1954 for the year 1937 to 1357 to 1358 Firstly, the plaintiffs have also filed certified copy of the suit register of the rent suit, which has been marked as Exhibit 2. And this is to prove that the defendant number 1, Ramdhani Tiwari, had filed a rent suit against Gaya Prasad, which was registered as rent suit number 506 of 4344. In the written statement, the case of the defendant regarding this rent suit is that this defendant have got no knowledge about the same, and it must be fictitious suit. But the certified copy of the rent suit register tells another story. It proves that the defendant number 1 is not a truthful person, and he has made pleas befitting to him without caring for the truth. This will be more evident if we scrutinize the evidence of this defendant. He has said that he had never filed a return showing Gaya Prasad as Mukarrari Rayat, but he has himself filed certified copy of the Jamindari return, which proves beyond any shadow of doubt that he has actually shown Gaya Prasad as the Mukarrari tenant in possession of the suit land. Similarly, he has stated that the suit land was never settled to Haridas, but in cross-examination he has said that he does not know about the settlement of the suit land to Haridas, nor he has made an attempt to know about the same. In the written statement, he has pleaded that 15 decimals of land in the suit plot belong to defendant number 2 to 4. But in this evidence, he has said that the entire 48 decimals of land in suit plot is in the possession, and none of his other co-sharers are in possession over any portion of the suit plot. He has gone to the extent of disowning his own written statement also. Therefore, we find from his evidence that he has made statement
इतना detailed order है, every evidence has been considered. You have also filed your zamindari return, stating that yes, he is there. तो अब आपके rent assessment का क्या ही relevance? Everything is there. Registered deed is there. Returns are there. Zamindari rent receipt, Exhibit 7 series is an admitted document. How can you manage? कुछ है नहीं आपके पास. Concurrent finding.
Concurrent.
अब बताइए क्या करना. It's not one piece of every evidence has to be considered. एक चीज खोल के consider. कुछ नहीं. नहीं कुछ बोलने का नहीं है. It's an observation.
Yes.
If you think that anything is incorrectly stated या कुछ गलत है, वैसा कुछ तो substantial
Only
question
thing
of
in
law
my
भी नहीं.
favor is that the rent assessment in the year 1969.
How does that? How will that make any difference? It will not make any difference.
And that was the only substantial question.
That was only substantial question. आपको क्या बोलना है?
At the appellate stage, your lordship will find that only one question was raised. That is, at para 16, internal page 9 of the appellate. The only para 18 became. appellate court.
At 18.
Children. The only point to be determined is whether the judgment and decree in question is liable to be sustained for which the issues were framed by the court below, be taken as cause for determination. And develop the entire fact, considering the document filed by the plaintiff. The suit was decreed.
रिटर्न तो दोनों ने एग्जिबिट करा है,
दोनों एग्जिबिट कराए,
ऐसा नहीं है कि एक ने दोनों ने
दोनों
एग्जिबिट
एग्जिबिट कराए.
A rent receipt is an admitted document.
Yes.
7 cities is जमींदारी rent receipt.
Yes.
फिर क्या बचा? Settlement is a registered document. अब दिखाएं इसका फाइंडिंग आप पढ़िए, फाइंडिंग पढ़िए आप लिखो का नहीं पढ़े सर को मत परेशान करिए, आप पढ़िए फाइंडिंग सर क्या है सर.
From para 21 onwards. It is admitted fact that in the case that the suit land originally belonged to one Swayamvar Tiwari, the ancestor of contesting defendants. Though it is not clearly admitted, but it is established that the suit plot 733 area 48 decimals situated in village Redma is Darton Hill, Palamu, was Gair Majorwa land. Written statement on this point is that it was Gair Majorwa land, but further it was used by then landlord as Harihar, and it not appeared in the record of survey of settlement as such. But no settlement is adduced in this case. Learned counsel appearing for the appellants admitted the fact that there is only one survey and settlement in the district, and that is cadastral survey. And in that survey, the land was recorded in the name of ancestor of contesting defendants as Gair Majorwa land. Situation changed with the execution of deed exhibit 5, registered deed dated 27/10/25 in favor of one Haridas, through which some interest of the land was transferred in favor of Haridas, the detail of which will be discussed later on. But this deed came in existence just after 1 year. Haridas transferred all his rights through executing exhibit 6 in favor of one Lal Mohan Prasad, minor son of Gaya Prasad, for 8 kattas of land. Plot number 733. Both these deeds have been designed as Mukarri deeds, and admittedly a right to possess has been transferred through these deeds. About these deeds, it has been said that defendants have no knowledge about the deed, and if any deed is produced, that is a forged one. But in case if no forgery is done, there is nothing for the court to consider about it being a forged one. This aspect of the fact has been elaborately and rightly discussed and concluded by the court below. Again, I would like to say that Exhibit 5 was executed and thereafter Exhibit 6 was executed. About Exhibit 6, it is said that the same was executed in favor of Lal Mohan Prasad. Actually, it was a property of Gaya Prasad, who acquired the same in the name of his minor son Lal Mohan Prasad. Though a dispute has been raised on behalf of the defendant appellants that it cannot be taken as a valid deed as before revenue authorities, Lal Mohan Prasad appeared and asserted to be land of his exclusive, and in the plaint it has been said to be of the heirs of Gaya Prasad. All the heirs of Gaya Prasad have been made party, and many members of the family have participated in contesting the suit, including the heirs of Lal Mohan Prasad, and are stating this property as joint family property, as they assert that there are properties in the family in the name of different members having share of all the members. So it cannot be treated otherwise except a joint family property, and in that case, existence of property and name of any other member is of no importance. Even a member acquiring the property of his own earning is entitled to throw the property in common stock of the joint family property. So this point has no importance for determination of right of the plaintiffs over the suit land. As about possession of Gaya Prasad over the land in question and descendants of Gaya Prasad, rent receipts issued by Ramdhani Tiwari and Shivnarayan Tiwari, sons of Swayamvar Tiwari, are Exhibit 7 series, which have been issued by them till vesting of zamindari with the state. Regarding these receipts, it is stated that they have not been issued by the defendant, and further no plot number is mentioned in these receipts. The appellants further submitted that the plaintiffs had another land in Moda Redwa, and rent receipts are concerning that land. One thing is important regarding these receipts, that in all these receipts, rupees 8 has been realized as rent. Exhibit 5 and Exhibit 6 also provides that rupees 8 also provides about rupees 8 to the land. After declaration of the vesting of the estate to the state, the first thing was to be done by them landlords, and that was to file returns showing that the lands occupied by Regia, and further they were to take steps for assessment of the rent for the land in their occupation. So return in the first document produced to the state about the nature and state of the property. Issuance of rent receipt and filing of return both have been denied by the contesting defendants. One of the defendants, Anthony Tiwari, examined in the case as DW1 in para 70, states that the rent receipts filed in this case are in his own handwriting. This is much sufficient to conclude that the possession of transfer of Haridas was also admitted by the defendants. Though an explanation has been given that another 10 kattha of land was given to Gaya Prasad in Moda Redma, for which he was paying rupees 8 as rent. But this contention finds no corroboration from any point. In para 27 of the plate, one of the plaintiffs, Pyare Mohan Prasad, SPW7, states that his another land was acquisition by the state and no rent was payable for that land as the land was Magarid land. There is deed exhibit 6A on record to show that this deed was executed in favor of plaintiffs and sister. An area right was purchased through this deed and no rent was to be paid. Only this much contention cannot have the contesting defendant regarding plaintiffs having land in Redma for which rent receipts were issued. As per the return, there are two documents and that are Exhibit 4 and 9. Exhibit 9 has been filed on behalf of the contesting defendants and used by the plaintiffs. In both these documents, in column therein at serial number 6, Gaya Prasad has been shown as Mukarrid and the rent has been shown as rupees 8. Now there is no scope to deviate from the above recitals. In such a case, any assertion regarding possession of the land made on behalf of the contesting defendant is of no avail to them. Further, oral evidence has been adduced on behalf of the parties on the point of possession, but in face of the above documents regarding possession, they are of no avail and needs no discussion. Thus, conclusion arrived by the court below on point of possession of Haridas remains sustained. As above right, title and interest of Gaya Prasad and his family members regarding suit law, the learned counsel for the appellants failed to point out any provision as there was any bar to transfer such right. The interest that is regarding right to possess was transferred by Shramva Tiwari in favor of Haridas and that was then transferred in favor of Gaya Prasad in the name of his minor son Lal Mohan Prasad. Thus, it is all before vesting of estate into the state of Bihar, which is relevant point when the user of the land were made entitled for the realty interest and the lands entered in the return for which the rent was realized by the landlord was to be accepted, which was also accepted by the state government. And if a person was paying rent to the landlord, that was the fair rent to be paid to the state government. And in case land was in khas possession, then it was for the landlord to take steps for assessment of rent. All the lands retained by the landlord vested in the state except the lands provided under section 5, 6 and 7 on payment of rent to the state. Homestead as provided under section 5 of Bihar Land Reforms Act settled with the landlord free of rent, while other lands was to be retained in possession on payment of rent, for which it was for the landlord to take steps for assessment of its rent, and M form was prescribed for initiation of the proceeding for assessment. This point is relevant for the instant case for determining the rights of both the parties. On one hand, it is said on behalf of the contesting defendants that the rent was assessed in their favor on the basis of K form, and on the other hand, they assert that no steps were taken on behalf of the plaintiffs for assessment of rent in their favor. According to them, if no steps was taken on behalf of the plaintiffs, then the land vested in the state and no interest can be claimed on their behalf. As about the assessment of rent in defendant's favor,
Fully discussed, everything is fully discussed. Further, when it comes to pleading on behalf of the parties, This appeal has been filed against the judgment dated 27/8/1996. Within bracket decree signed on 9/9/1996, bracket close, passed by the learned 4th Additional District and Jharkhand entitled Appeal number 31 of 1987, dismissing the appeal and confirming the judgment and decree dated 14/8/1987, passed by subordinate Judge Roman II at Daltonganj, entitled suit number 86 of 1978, decreeing the suit of the plaintiff. The defendants have lost in both the courts, and accordingly, they are the appellant before this court. This appeal was admitted for final hearing by order dated 25/11/1999 on the following substantial question of law: whether courts below erred in law in ignoring assessment of rent under Section 6 of Bihar Land Reforms Act 1950 in the name of the defendants dash appellants in the complaints. The learned counsel for the appellant, by assailing the impugned judgments, has submitted that though there are concurrent findings recorded by both the courts, but the rent having been assessed in favor of the defendants, the finding of title and possession in favor of the plaintiffs could not have been passed. Yeah. He has submitted that this aspect of the matter has not been properly considered by both the courts, and therefore the substantial question of law is to be answered in favor of the appellants. The learned counsel, appearing on behalf of the respondents, on the other hand, has submitted that both the courts have scrutinized all the materials on record, and the plaintiff was claiming title on the basis of a registered settlement and was the purchaser from the settling under the registered settlement way back in the year 1926. The settlement was issued, which was followed by issuance of zamindari rent receipt, and even in the return, the zamindar had shown the possession of the plaintiff, and merely because the rent was assessed in favor of the defendants, the same is not conclusive to decide the title of the case. He has also submitted that both the courts have scrutinized all the materials placed on record, and there is no perversity in the matter of appreciation of materials on record. Even the factum that the rent was assessed in favor of the defendants has also been duly considered by both the courts. The learned counsel has submitted that the substantial question of law be answered in favor of the respondents. That's all. यही इनका सबमिशन आपका लिखा दिया थे तो परवर्सिटी है, इनका लिखा दिया रिपोर्ट परवर्सिटी, इतना ही तो बचेगा, क्या बचेगा? After hearing the learned counsel for the parties,
रजिस्टर्ड डीड मुझे एक मुकर्ररी राइट कहा रहा है
वो लिखा दिया।
उसका बस देखना जरूरी होगा क्योंकि उसी पे डिसाइड हुआ है हमारा मुकर्ररी है कि नहीं अपडेट कोर्ट की जजमेंट में आया है।
हाँ वो तो आया है, लेकिन साथ में उन्होंने वो भी दिखाया है कि ये हेरिटेबल राइट।
हाँ उनका फाइंडिंग आया है
वो फाइंडिंग
क्योंकि एक और वो प्लेनली है कि सिंस इट वाज शोन इन द रिटर्न एज अ रैयत क्योंकि बट आवर कंटेंशन इज दैट इन 1955-56 द मुकर्ररी राइट गॉट वैनिश्ड but we also filed return. Both the things cannot go together. That is our admission, and the rent receipts are also admission. The rent receipt can be explained that since it was a mukarrar right, therefore we admitted it. But PW1 also admits that it was a mukarrar right. That is the bone of contention.
But what is recorded in the deed has to be.
That is. In the deed, it is a mukarrari.
Mukarrari right with
Inheritable.
hereditary right.
Inheritable.
Inheritable.
Heritable. ठीक है, उस point पे है.
लिखा है?
हाँ, थोड़ा सा रहेगा, ठीक रहेगा.
The learned counsel for the appellant in response has submitted that in the registered deed of settlement, he has submitted that the right through settlement was only mukarrari right, and the same was not heritable.
And PW7 has admitted lordship in his deposition in para 34 of the appellate court statement.
The PW7 in his
Who is one of the
deposition,
plaintiff?
who in his deposition and who is one of the plaintiff has admitted that the right was a mukarrari right,
Which extinguished in 1955-56.
which extinguished in 1955-56. The learned counsel submits that this aspect of the matter has not been properly considered, and once the person in whose favor mukarrari right was given through settlement expires, then the property will revert back to the landlord. Filing of return is of no consequence. However, during the course of argument, it is not in dispute that so far as the registered deed of settlement is concerned, it has been specifically mentioned therein that it was a mukarrari right and heritable right. As per the plaint, the suit land was recorded as Gair Majura land in the course of last survey and settlement operation, and the plaintiff claimed that the suit property from one Haridas, who in turn acquired the property by a registered sale deed of the year 1926, who has obtained mukarrari Dwami life interest lease from one Swayamvar Tiwari through a registered deed of settlement dated 28/10/1925 on annual rent of ₹8 only. The plaintiff claimed that one Gaya Prasad, the pleader of Daltonganj, purchased the suit property in the name of Lalgaon Prasad, his minor son, and came in possession, and claimed to have built kacha house and kacha wall over the property by Haridas over the suit property. It was claimed that the kacha wall was converted into a brick wall later on. Further case of the plaintiff was that the demand for land could not be opened and the petition was rejected by the circle officer, and the rent was assessed in the name of the defendant, and there was a dispute before the revenue authorities, and ultimately the matter travelled till the member board of revenue, and thereafter the suit was filed in the year 1978. On the other hand, the defendants claimed that the dependent number as per the plaintiff, Gaya Prasad died leaving behind his children who were plaintiff number 1 to 4 and pro forma dependent number 5 to 8. And Lal Mohan Prasad also died in the year 1976, leaving behind plaintiff number 5 to 11 and pro forma dependent number 9 as his legal heirs and representative. The defendant number 1 to 4 were the principal defendants who filed joint written statement. The case of the contesting defendant was that though it was admitted that the suit property was Gair Majuba Malik, but according to these defendants, the entire area was used as Khalian by the ancestors of defendant number 1 to 4 as a landlord and was recorded as such during the last survey settlement operation. This plot was also used as Niksar of the landlord because adjoining to it, defendants had their ancestral house and it was still there. It was further case of the defendants that since the LA's deed of settlement, which is said to have been executed in the year 1925 in favor of Haridas, was not made in their presence, nor they have any knowledge about such document in favor of Haridas, they did not admit the same, that Haridas was inducted as a tenant over the suit property. It was asserted that there has been no sale or lease in favor of Haridas and he never came in possession of the suit property, and the sale document must be forged and not acted upon. The fact about construction of boundary wall and etc. over the suit property by the plaintiff was also denied. It was similarly denied that the plaintiffs, that the property was purchased by Gaya Prasad, the predecessor in interest / ancestor of the plaintiffs. It was also their case that it was also denied that the property was mutated in the name of Harida. The property was mutated in the office of landlord who realized rent from Gaya Prasad and granted rent receipt in the name of Gaya Prasad. It was also denied that the defendants had filed any rent suit for realization of arrears of rent with respect to the suit land. it was also stated that Gaya Prasad was never a tenant over the suit land, and it was denied that the plaintiffs, that Gaya Prasad was shown as a tenant in the return filed under Section 3B of the Bihar Land Reforms Act. It was alleged that the entry of name of Gaya Prasad in the return was a result of manipulation. It was also asserted that the defendants were found in possession of the suit land on spot inquiry by the revenue authorities, and accordingly the rent was assessed in their name. It was stated that the member board of revenue, before whom the matter travelled with respect to the orders passed by the revenue authorities, had set aside the order of the initial collector by stating that it was wholly without jurisdiction and perverse. And the orders passed, order of assessment of rent cannot be questioned in civil court. The learned trial court framed as many as 9 issues for consideration. The issue number 6, 7, and 8 are the issues which are relevant so far as the substantial question of law involved in the present case are concerned. The issue number 6 was decided by the learned trial court by paragraph 11 onwards. The learned trial court by the learned trial court reported that it was an admitted case of the parties that the suit land is a part of survey plot number 733 measuring 48 decimal, standing recorded in the as Gair Majurwa Malik in the last cadastral survey in the name of Swainbur Tiwari, and they had interest to the extent of 10 pi and odd. The court referred to the registered patta executed by ex-landlord Swainbur Tiwari, which is dated 28/10/1925, by which the suit land, that is 8 kattha in the survey plot number 733, was settled in favor of Haridas on yearly rental of rupees 8, rupees 8, and he was put in possession. The learned court considered the materials on record and ultimately held that Exhibit 5 was a genuine document. Thereafter, the learned court examined the recitals made in Exhibit 5 and observed that the recitals indicated that the settlement was for the settlee as well as for his heirs, subject to payment of rent and cess payable from time to time. And they were at liberty to cultivate or use the land in whatever manner. The court was of the view that the recitals made in the registered deed Exhibit 5 were binding on the parties. The learned court also examined the oral and documentary evidences placed on record and observed that the defendants cannot be allowed to say that Haridas was not in possession of the suit land. The court also recorded that Exhibit 6 was the sale deed executed by, registered sale deed executed by Haridas and the sale deed executed by Haridas stipulated that he had constructed a kacha house and kacha well over the suit land and thereafter Haridas had expired. The learned court and gave a definite finding in paragraph 13 that the suit land was settled to Haridas and he was put in possession over the same, and the said settlement had created hereditary interest too, and the issue was decided in favor of the plaintiff. While deciding issue number 7, the learned court considered the case of the parties and found that the evidence of DW1, Ramdhani Tiwari, the defendant number 1, that he admitted that he had granted rent receipts, Exhibit 7 within bracket E, Exhibit 7 within bracket F to Exhibit 7 within bracket H, which are all in the name of Gaya Prasad. The court also recorded that the defendants have also filed certified copy of the zamindari return which was filed by these defendants under section 3B of the Bihar Land Reforms Act, which has been used by the plaintiff and was marked Exhibit 9. The court recorded that this return also shows that the property was in possession of Gaya Prasad. And this matched with the case of the plaintiff that the property was settled to Haridas by virtue of registered deed dated 22/7/1926, and then the property was sold to Gaya Prasad, was purchased by Gaya Prasad in the name of his minor son Lal Mohan Prasad from Ravidas. The sale deed was, in the opinion of the learned trial court, the sale deed was of an unimpeachable nature. The learned court also recorded that from the side of the defendants there was no evidence to discard the aforesaid documents. The learned court recorded that the plaintiffs had also filed the zamindari rent receipts granted by the ex-landlord, which were marked Exhibit 7 series, and the defendant had admitted that the rent receipts were granted by them. The court recorded that this proved beyond, therefore said proved beyond doubt that the defendant had recognized Gaya Prasad as a tenant, for which rent receipt was also issued. The learned court ultimately further considered the oral and documentary evidences and held that there are certain admissions of the contesting defendants in the form of documentary evidences to show that Gaya Prasad was in possession, and the evidence of the witnesses on behalf of the defendants did not inspire confidence and appeared to be totally untruthful testimony. The defendant number 1, who was examined as DW1, himself last sentence. The learned court ultimately held that in paragraph 17 that on careful consideration of oral and documentary evidences adduced by the parties, there was no hesitation in coming to a conclusion that Gaya Prasad had actually purchased the suit land from the settlee Haridas by a registered sale deed and acquired title and also remained in possession till his lifetime. The issue was decided in favor of the plaintiffs. The issue number 3 and 8 were taken up together, and it was held that the defendant number 1 failed to prove dispossession of the plaintiff, and they must be deemed to be in possession of the land. The plea of adverse possession of the defendant was also rejected. And ultimately the suit was decreed. So far as the learned first appellate court is concerned, the court has also taken into consideration the court in paragraph 18, the court was of the view that the only point to be determined was whether the judgment and decree in question was liable to be sustained, for which the court issues were framed by the court were taken as the points for determination. The learned First Appellate Court also considered the materials on record and gave concurring findings. And dismissed the appeal. The learned so far as the substantial question of law involved in this case is concerned, the same is relating to only one aspect of the matter, that is assessment of rent under Section 6 under Bihar Land Reforms Act in the name of the defendant/appellants. This court finds that there are concurrent findings recorded by both the courts in connection with the fact that Gaya Prasad had acquired the property by registered sale deed from Haridas, who in turn acquired the property by way of settlement by the ex-landlord by way of registered deed way back in the year 1926. Both the courts have also recorded concurrent findings that none less than the defendant had admitted about issuance of rent receipt in favor of Gaya Prasad. And there is a concurrent finding recorded by both the courts that the rent receipts were in connection with the property involved in the present case. This court also finds that both the courts have scrutinized the return filed by the ex-landlord, which was exhibited also by the defendant, in which Gaya Prasad was shown to be one of the tenants with respect to the suit property. This court also finds that the courts have examined the true import of the registered sale deed of the year 1926, which was executed by the ex-landlord in favor of Ravidas, and have recorded concurrent findings that it was not only creation of Mukurari, but was also creating hereditary rights in favor of the heirs of Haridas. And therefore the right was heritable right. Therefore the argument of the learned counsel for the appellant that it was only Mukurari right which extinguished upon death of Haridas is contrary to the sale deed and also contrary to the findings recorded by both the courts by referring to the sale deed, the settlement deed involved in the present case. Both the courts have given concurrent finding with respect to the possession of Gaya Prasad and the claim of the defendant regarding possession has also been denied. This court finds that merely because there was rent assessed in favor of the defendant, which was subject matter of challenge which was subject matter of consideration by both the courts, is not conclusive. Rather, the courts have considered all the materials on record and come to a definite finding with respect to transfer in favor of Haridas and then to Gaya Prasad. In view of the posted facts and circumstances, the courts below have not erred in law, has neither erred in law nor they have ignored the assessment of rent. Rather, the courts below have considered totality of all the materials placed on record to come to the finding. The substantial question of law is accordingly decided against the appellant and in favor of the respondents. This appeal is accordingly dismissed. यहाँ लिखा देना सबसे
हाँ
आसान
easier for everyone.
और मेरे लिए भी बाकी तो करेक्शन तो आपको पता ही है वो होगा ही
कुछ मिस हो रहा है कुछ हो रहा है, we are also there to assist your
ठीक है।
coaches.
चेम्बर में लिखाने में 4 टाइम्स ज़्यादा टाइम लगता है। एक बार उठने के बाद ना चीज़ें थोड़ी सी फिर पता चलता है 2 दिन बाद लिखा रहे हैं तो दिक्कत